urgent revision petition was filed yesterday. It has not been listed. Can it be taken up tomorrow, madam?
We have filed the IA in a pending FAO, which is of urgent nature. Can it be listed, Lordship, day after tomorrow or tomorrow, whenever it's ready?
Day after tomorrow.
Day after tomorrow. Very good.
Lordship, this MSC appeal already a Bakuja proceeding has been started. Lordship, can it be listed tomorrow? This is not much complicated. It is on quantum and we are ready to deposit 50% for admission. Highly obliged.
My lord, this appeal may be listed for the withdrawal.
When?
Day after tomorrow.
Okay.
My lord, it's in testamentary appeal. It was last posted on 21/11/25.
For hearing,
Become any day before vacation.
before, at what stage? What stage? After vacation in the deadline. 20 July.
Lordship, I beg to mention for a CRP, Lordship, we are the opposite party. Lordship, finally, this matter will be taken day after tomorrow, Lordship.
What is the urgency?
Lordship, the matter was referred to mediation, but mediation was failed and referred, sent to the court, Lordship. The case was sent to the court, and during the mediation process, the wife received 13 lakhs from the husband. As per the
You are husband or wife?
husband, Lordship. As per the settlement, Lordship. Now the wife, after receiving the money, she failed to comply with the terms and conditions of the settlement
What terms?
agreed between them, Lordship.
What terms?
Lordship, after
Immediately after vacation. 17 July.
May I please, Lordship, with the concern of the other side, I beg to mention item number 16, Lordship. Lordship, my senior, Mr. D. Kalita, is suffering from back pain. Lordship, kindly adjourn the matter for today.
What is your name?
Our court,
Heard Miss R. Kaur, learned counsel for
what's the date, Lordship?
the petitioner who seeks an adjournment on the ground that conducting counsel for the petitioner, Mr. D. Kalita, is not well. She submits that she has informed learned counsel for the respondents regarding her prayer for adjournment, who does not have any objection to same. Stop. Hence, the prayer is allowed. Let this matter be 29 July.
Okay.
Wait, no, Lordship. The two matters, Lordship, MSC appeals, have been settled outside the court. Let the matter be listed on 24th.
Before 25th.
25th.
May I please, your lordship? Lordship, I beg to mention for listing of an RSA, it was filed in the month of May, but it did not come up before, it was not taken up before any court. So there is an urgent need for a stay order. Can it come up on Thursday, my lord?
Okay.
Much obliged.
May I please? Lordship, my award was challenged by the insurance company, Lordship, by filing MSC bill along with a condonation petition. Condonation petition disposed of and the matter was fixed for admission hearing on last night. 19th was listed for admission, but the insurance company took time due to their problem, Lordship. So, Lordship, this matter may be taken up this week within the.
What is the urgency?
Lordship, claimant is accident occurred long back, Lordship. In judgment passed last year.
20 July.
Before any date, Lordship. Case was listed on 19th.
25th June.
Obliged, highly.
May I please, Lordship, I wish to mention one MSC appeal for orders, my lord. Any date, my lord, please.
After vacation. 20 July.
Another matter, my lord, RSA for hearing.
Hearing,
20.
go to the registry, pray before registry.
May I please, your lordship? With the consent of other side, I beg to mention item number 17.
Got it listed by mentioning, my lord. Can it be listed immediately after vacation, my lord?
What is your name?
P. Kolita.
Heard Miss P. Kalita, learned counsel for the petitioner, who prays for an adjournment. Also, Mr. P. Sundi, learned counsel for respondent number 2, who does not raise any objection to the prayer. Hence, the prayer is allowed. Let this matter be listed.
Lordship,
29 July.
Lordship, I'm appearing for the learned counsel P. Kolita.
You are also P. Kalita.
No, I'm J. Thakuria.
J. Thakuria appearing for P.
Not
Kalita.
that, my lord, I do not have objection, my lord, only because she has paid on the medical grounds, my lord, that's why I'm conceding, my lord. I got it listed by mentioning, my lord.
Mention Korigo. Considering the fact that the adjournment is sought for on medical grounds, learned counsel for respondent does not raises any objection to the said prayer.
Much obliged.
May I please, your lordship, I beg to mention listing of RSA matter 2018.
What stage?
Admissions. Any date, my lord, before that.
At what stage it is pending? At what stage it is pending? Admission stage. 29 July.
May I please, Lordship, because I beg to mention item number 18, Lordship. Lordship, due to some personal difficulty, Lordship, Senior Counsel D. Sharma, Lordship. So matter may come after vacation, Lordship.
Today
also not available.
What is your name?
S.J. Sohoria, Lordship.
Heard Mr. S. J. Soharia, learned counsel for the petitioner, who seeks an adjournment on the ground of personal difficulty of the conducting counsel for the petitioner. Also heard Mr. K. Da, learned counsel for the learned additional public prosecutor, who also sought some time for production of the case diary. Prayer is allowed. Let this matter be listed after vacation. 21 July.
Deeply obliged.
My lord, I pray for listing of a RSA
At what stage?
order. Data, my lord, date I want to give,
No? 17 July.
17. So, my lord, 14, 15 or 16, because 17th we are having case. 14th, 15th or 16th.
This is also a case. So you have to choose.
My lord, I don't want to say this one.
17.
17.
Yes.
On other occasion, it was Lordship charge sheeted. It is not sealed. Only
Hmm.
item number 18.
Okay. Repeat submission to Katidio. Issue reminder for scan copy of the trial court records. Yes, Mr. Gupta.
I beg to mention item 6. Item 25, Lord. In behalf of R. Devi, Lord, she is in bereavement.
You have informed the other side.
Not informed.
We'll allow this, but we are not passing any
No.
order now.
Not in-
We will, when the matter is called, we will allow it. Okay. Yes.
May it please your lordship. Lordship, I beg to mention for listing of a RSA lordship for orders.
17 July.
Deeply obliged. Lordship.
May I please, Lordship? Well, bail application under POCSO Act, my lord, notice may go on.
Heard Mr. I. Chaudhary, learned counsel for the petitioner. Charge sheeted case.
Charge sheeted case, my lord.
Also heard Mr. K. Das, learned additional public prosecutor. Issue notice to the respondent number 2. The petitioner shall take steps for issuance of notice to the respondent number 2 in pursuant to the prevailing notification of the registry in this regard within 7 days from the date of this order, returnable on 21 July.
Obliged.
Let also the scanned copy of the trial court records as well as scanned copy of the connected case diary be called for from the trial court. Registry to take steps for requisitioning the scanned copy. List accordingly.
May I please, also, my lord, in this case, my lord, we are seeking transfer, my lord, from Obhaipuri to my lord Kamrup. My lord, the husband, my lord, the respondent, has filed a suit for restitution of conjugal right at Obhaipuri, my lord. And so, my lord, and as the, my lord,
Your wife,
I'm the wife, my lord.
where,
Working at, my lord, at Amingaon in a hospital, my lord, as a nurse, my lord. Not multi-specialty hospital.
who is number 2, petitioner number 2, 3?
My lord, in the title suit filed by the, my lord, respondent, he has made, my lord, the father, mother, and sister, and also the uncle
In a
of the
restitution of
part.
conjugal rights
Yes,
case,
he has made, my lord.
heard Mr. I. Chaudhary, learned counsel for the petitioner. This application under section 24 of the Code of Civil Procedure 1908 has been filed for transfer of the title suit number 66/2026 pending before the Court of London. Civil Judge Senior, Civil Judge Junior Division, Abhayapuri, to a court of competent jurisdiction at
My lord, we are saying family court because because the in Amingaon also, my lord, the matters of so far related to family court, they are sent before my lord principal just family court, my lord.
competent jurisdiction at Kamrup or Kamrup Metro. Issue notice to the respondents. The petitioner shall take steps for issuance of notice upon the respondents by speed post as well as by usual mode within 7 days of date of this order, returnable on 3rd of August.
That's the Indian protection, my lord.
Considering the averments made in the petition as well as submissions made by learned counsel for the petitioner, the further proceeding of title suit number 66/2026 shall remain stayed till the next returnable date. List according.
My lord, my lord, one, just one, it is title suit in bracket, it is M, my lord.
Title suit within
Bracket
bracket.
of M. Bracket.
Title four,
Let me, your lordship. Here, my lord. The impugn order is in case number
Lordship, before my learned friend starts, I would like to point out some, I think, legal defect. That is, this is a petition under Article 227 and has been registered in the CRP, Your Lordship. But the order which has been challenged, Your Lordship, that is granting of injunction. For granting of injunction, Your Lordship, 327 does not apply. Because there is specific provision in the CPC under Order 43, Rule 1R, Your Lordship. If granted or not granted, Your Lordship, that is the subject matter under Order 43, Rule 1. That's why, Your Lordship, this petition 227, I don't think that it is maintainable.
My lord, my submission regarding that is that, my lord, though we have challenged the injunction petition, my lord, there is a case, we have also under rule order 7, rule 11, there is a petition pending before the civil judge, my lord. And without deciding that petition, my lord, the honorable court below has granted the injunction, my lord.
But
So
where is the impugn order?
impugn order is based, that is granting injunction, my lord. That is impugn order, that is right, my lord. That is
Then that is appealable order. You can take any plea before the appellate court.
my lord, my
If injunction is granted without deciding the rejection,
Yes, my lord.
Your Lordship.
Yes, my lord.
Injunction is
that
interpreted.
plea can be taken before the appellate court also. But since the order is an appealable order,
Is appealable.
220, whether 227 lies or not, it does not lie.
My lord, only take,
And
whether
this
at 2
other-
o'clock, my lord,
Other
whether I-
points raised, Your Honor, Order 7, Rule 11, that petition is pending disposal, Your Lordship. They have taken time. In the trial court, Your Lordship, they have taken
No,
time.
that is another aspect.
For
But,
there is no order, Your Lordship. That cannot be challenged now.
but this order is apparently an appealable order.
that is true, my lord.
227 does not lie.
My lord, kindly take it to, at 2 p.m., my lord.
At
Whether-
you will withdraw it.
Maybe, my lord, I may withdraw the matter, my lord.
Okay, let her come.
On some other date, Your Lord.
No, let us decide it today itself because apparently it is not maintainable. Let us,
Day after tomorrow. As if Mongol goodbye.
no, why do you,
At 2, my lord. I'll
at 2 will
Now, add to your lordship, I have difficulties, your lordship.
Tomorrow, my.
This CRPIO is not maintainable. At 2, we are either dismissing it or she will withdraw it unless she comes with some other explanation. At 2, you have some difficulty at 2. Heard Miss A. Gayan, Planet Counsel for the petitioner. Also heard Mr. A. Ali, S. Ali, Learned Counsel for the caveator. On request of Learned Counsel for the petitioner, let this matter be listed tomorrow.
Most obliged, my lord. Tomorrow.
Tomorrow, your lordship.
Can we discuss?
Tomorrow.
May I please, Lordship? Lordship, earlier one petition was filed pertaining to this same subject matter, Lordship, but that was dismissed for non-joinder of necessary parties, without adjudicating on merits. Lordship, kindly find at page 102, Lordship. Page 102. That was filed on similar subject matter. Giving liberty to file with properly constituted petition. Lordship, accordingly, I have filed this fresh petition. And in earlier petition, Lordship, my Lordship had passed an interim order at page 22, page 97, Lordship.
Page
Page
90.
97. Facts are same, Lordship, and it is already reflected in this interim order passed by your Lordship. Only fact that earlier some necessary parties were not made party in that petition. Other facts, circumstances are same, Lordship. So, a Lordship can pass this similar order.
No, when this order was passed.
That was passed, Lordship, at 24/11/2025. Order passed by your Lordship.
Same order has been impugned here. Where is it?
Same order impugned.
Where is the impugned order?
Page 94, Lordship.
Page?
Page 94. 94 onwards. Earlier occasion also, Lordship, the same order was impugned. And ground taken is also same, Lordship, in this instant petition.
Heard Mr. A. Islam, the Learned Counsel for the petitioners. petitioner. This application under Article 227 of the Constitution of India, read with Section 151 of the Code of Civil Procedure 1908, has been filed by the petitioner impugning the order dated 27/2/2020. No, you are impugning 1/3/2020. Impugning the order dated 1/3/2023, passed by the Court of Learned Civil Judge Dhubri in the title execution case number 2/2018. Stop. The learned counsel for the petitioner has submitted that prior to filing of the instant CRPIO, the petitioner had approached this court by filing another CRPIO, which was registered as CRPIO number 525/2024. However, by order dated 25/2026, the petition, the said CRPIO was dismissed on account of non-joinder of necessary parties without the matter being heard on merit. Stop. It was specifically mentioned in the said order that the petitioner is not precluded from approaching this court again in appropriate manner. Stop. The learned counsel for the petitioner has submitted that accordingly the petitioner has filed the instant CRPIO by impleading the parties which were not impleaded by him on the earlier occasions. Code para 3 from page 98, 3, 4, 5, 6, 7, 8, 9. Issue notice to the respondents. The petitioner shall take steps for issuance of notice upon the respondents by speed post as well as by usual mode within 7 days from the date of this order, returnable on 3rd of August. Stop. In the meanwhile, considering the submissions made by learned counsel for the petitioner as discussed in the foregoing paragraphs, further proceeding of title execution case number 2/2018, pending before the Court of Learned Civil Judge Senior Division Dhubri shall remain stayed till next returnable date. List record.
Obliged.
Item 6.
May I please your lordship, my lord?
Yes.
My lord, by way of this petition, my lord, the petitioner challenges the correctness and validity of the order dated 28/4/26, which your lordship finds at page 87, my lord. That petition was filed under, my lord, Order 7, Rule 11, and that was rejected by this impugned order, my lord. And my lord, kindly see the genesis of this case, my lord.
Page number 80.
87, my lord. It starts at page number 87, my lord.
When is the next date fixed?
Next day, I am not aware, my lord.
In the suit,
In the suit, my lord, the next day, I am not aware, my lord.
okay, we'll issue notice.
Notice and stay all further proceedings in the suit.
Stay unless you are aware of next date. You will not get stay.
I'll just find out, my lord. My lord, from this e-court service, my lord, so title suit number. Can this matter be taken up after the next item, my lord? I'll just come up with the next date, my lord.
Okay.
My lord.
We'll take it up after some time.
Yeah.
After some time.
Item 7.
Maybe. In this case, my lord, I am the plaintiff. There are two plaintiffs, my lord. One person has expired and another is still there, my lord. And for which, my lord, the earlier, my lord, fact is this, earlier the case was, my lord, decreed in my favor, in our favor. And against that, my lord, the defendant, my lord, filed a petition for vacating the same. And that was
Ex parte decree.
ex parte.
Okay.
And that was granted. With the condition that they have to deposit rupees 2,000 as a fine. But that was not given, deposited. So many case was proceeded, then they come to High Court. And High Court said yes, same again 2,000, and subsequently they deposited rupees 2,000 and case is going on. In the meantime, one of the plaintiff expired in 2024. And there was some delay in filing the in illegal petition. I filed legal petition, I continue with condition of delay petition. And that condition has been rejected.
Okay.
There is page.
Where is that order?
Yes. Kindly see page 61, yes. Annexure 11, page 61. Order dated 12/5/26.
What is your grievance? How the court is wrong?
Actually, my lord, in this case, I have stated there are one advocate, Ghaziur Rahman. He also, my lord, leading advocate of the case, my lord. But in the meantime, he went to perform Hajj, my lord. Thus, there was some delay. That purpose also. And the junior advocate, my lord, he tried to do the same, my lord, but that was some defective version, my lord. That is the allegation of the opposite party.
Who is the petitioner here?
Petitioner, my lord, here, my lord, the plaintiff.
Plaintiff or the legal heirs of deceased?
Yes. Plaintiff and legal heirs deceased. They are the petitioners.
Okay.
Next date may given 24/6 for cross examination.
Heard Mr. A. Rashid, learned counsel for the petitioner. Also, this application under Article 227 of the Constitution of India has been filed by the petitioners impugning the order dated 12/5/2026 passed by the Court of Learned Civil Judge Senior Division,
Junior division.
Junior Division, Nalbari,
One.
in connection with title suit number 34/2016, whereby the application for condonation of delay in filing the substitution petition for bringing on record the legal heirs of deceased plaintiff number 2 and also for setting aside abatement was dismissed. Issue notice to the respondent. The petitioners shall take steps for issuance of notice upon the respondent by speed post as well as by usual mode by within 7 days from the date of this order, returnable on 5th of August. List accordingly.
In the meantime, my lord, that date is 24/6 for cross. That may kindly be state proceed.
So you want stay of suit?
My lord, otherwise case in
Who is the plaintiff number 1?
plaintiff name is Mukib, okay, sorry, Korimali, and Mukib Miller, he expired. 2 persons. I have mentioned title suit, I have given Miller and XR 1, page 12.
Who has sworn the affidavit? Karimali.
Correct.
Stop. In the meanwhile, considering the averments made in the instant CRPIO as well as submissions made by learned counsel for the petitioner, further proceeding of title suit number 34/2016 shall remain stayed till next returnable date. List accordingly.
It is fixed today or not?
Today,
Yes.
then we'll take it up at 2. What is the next date? You have to inform me.
Today, it is fixed today.
You will be appearing today also before the trial court.
Somebody will be appearing. It's from Tejpur, my lord.
You take intimation. What is the next day?
Till then, my lord, let the further proceedings be stayed.
No, if next day,
Because
Depend-
ultimately, if evidence, because it is fixed for evidence today. And ultimately, my lord, if evidence is reduced and all, my lord, because the basic thing, kindly see the genesis of this case, my lord. I have litigated right from the, my lord,
no.
right from the trial court to
At-
this high
at-
court, my lord.
at
And
2,
I am a decree holder, my lord.
at 2, we'll take it up. Intimate about the next date.
But if the next date is not given, then also, my lord, by then.
Next date will be given by 2.
I'll try to collect one. Even
We'll-
if it is not given, then
Then we'll decide.
Yeah, please, Lordship. I am the petitioner plaintiff, my lord. And the plaintiff is the owner of 2 vehicles, my lord. The defendant take rent on the vehicle, my lord, for 7 years. After 7 years, the defendant failed to pay the rent, my lord. That is why I filed the petition, the plaintiff petitioner filed the suit for recovery of the vehicle and also area rent, my lord. And during the pendency of the petition also filed a petition for custody of the vehicle because the rent period is over 7 years, my lord. And to damage the counterblast of the petition filed by the plaintiff, my lord, he also filed an injunction petition to restrain the plaintiff owner for taking the vehicle, my lord. The impugned order passed on the same day, my lord, and the injunction petition order was also passed temporarily, and the vehicle custody petition was also passed on the same day. Earlier of the disposing my petition, the injunction was granted, my lord, and my petition was dismissed on the only ground that injunction was already granted to the defendant. That is why no custody of vehicle was may be allowed to the petitioner, my lord. My lord,
Now, which order you are impugning?
my lord, Annexure H, my lord, Annexure H, page 111, and its operative part 120, my lord. Annexure H, my lord, impugned. 120, my lord. Page start paragraph 7, my lord, operative part.
It starts from 100 and
111, my lord. Actually, 111 on the facts, my lord. but operative part on 120, my lord.
There is no 111. Your last page is 110. Last page of your petition is 100 numbered as 110. There is no 111. You compare your brief with the
Yes, my lord. Yes, my lord.
file. We'll take it up after some time.
My previous option, 9, 10, and 11, my lord. Same question involved. And between the, my lord, respondent, plaintiff, and three other flat owners. In this case, my lord, by imprint order dated, my lord, 21/5/2026 at page 81. My lord, prayer for granting time to file WS is straightway rejected, notwithstanding the fact that 90 days period is yet to be, my lord, expired. Because, my lord, they supplied the copy on.
Where is the impugned order?
Imprint order at page 81.
81.
81. Simply, my lord, arriving at a conclusion, finding that 90 days period expired, I failed to file WS. Therefore, my lord, my right to file WS stand forfeited. But the facts remain that, my lord, we made an application, my lord, seeking some time, because in terms of the order passed by, my lord, REDA, both the parties are directed to make a compromise. And process of, my lord, settlement is still on. So with, my lord, with all fairness, apprise the court that give us some time so that we can arrive at a amicable settlement. That was not looked into, no findings, no reason, simply by arriving at a conclusion that 90 days period expired. The law is well settled, my lord. In 2000, my lord, 19, 12 SCC at page 270. In that case, Supreme Court has referred to all other earlier cases and arrived at a positive conclusion that in case of non-commercial suit, maximum period is 120 days. That too, my lord, is directed. But only in case of commercial suit, period of 120 days is, my lord, mandatory. Therefore, lordship, my lord,
Show me that.
my lord. I have also referred to, my lord, in my petition itself, the judgment. Even then, I will, my lord, supply the copy.
Where is that 120 days?
Yes. Just a minute, my lord. Para 24 also I have mentioned, my lord, specifically. What बोले? खुल गया. I am having a one copy, my lord. 2019, 12 SCC page 270. Paras 8. In my petition also I have specifically mentioned regarding para 8.
Is it a commercial suit?
No, it is a non-commercial suit. It is a suit, my lord, seeking some compensation on the apprehension of some danger to life and property. It's absolutely bogus suit, my lord, because the case was pending before RADA. There was some violation of terms and conditions between the promoter and the flat owners. There was a, my lord, understanding of memorandum of understanding.
No, now what you want to?
Lordship can
Right.
issue notice and suspend the further proceeding.
No.
Otherwise, I have become non-suited. Whole object of the, my lord, fixing the time is not to, my lord,
Show me where the time is extended to 120 days.
my lord, I have given the judgment.
Please read.
Yes, my lord, having one copy, my lord. Para 8, Lordship, can you look into? Objective is not to, my lord, thwart justice, but to, my lord, advance the cause of justice. And we have made a, my lord, specific contention that since the process is pending for amicable settlement as directed by RARA, my lord, I have also annexed the copy order of the, my lord, passed by RARA. May I read, my lord? Para 8, I have quoted.
Yes.
The commercial codes, so that was amended in 2015, provided further that by the defendant.
But this is not a commercial case. How can?
My case is not a
It
commercial
is
case.
an ordinary suit.
Ordinary suit.
Order it through.
120 days. That
No.
is- Yes. Lordship, can you say? My lord, 120 days made, my lord, binding on respect of both commercial and non-commercial. Supreme Court says,
Where?
so 120 days in case of non-commercial suit is concerned, that is directory. And whereas, my lord, commercial suit 120 days is mandatory. Therefore, there is no any question for the court to grant any further extension in case of, my lord, non-commercial suit beyond 120 days.
No. Why are you bringing the concept of commercial suit? This is an ordinary title suit. So order 8 will be applicable.
Right. Therefore, my lord.
Which provides for maximum period of 90 days.
No, maximum period of 120 days.
Show me where.
Yes. Provided further that no court shall make an order to extend the time provided under Rule 1, Order 1, Rule 8, Order 1 for filing WS. A perusal of this provision would show that ordinarily a writ WS is still filed within a period of 30 days, shows that ordinarily a WS is still filed within a period of 30 days. However, grace period of further 90 days is granted, which the court may employ for the reason to be recorded in writing and on payment of such cost as it deems fit to allow such WS to come on records. What is of great importance is that the fact that beyond 120 days from the date of service of summons, defendant shall forfeit the right to file WS, and court will not allow WS to be taken on record. This is further buttressed by proviso in Order 8, Rule 10, so on, so on, so. Therefore, my lord, what I want to, my lord, apprise your lordship, there is a distinction made between the commercial and non-commercial suit, and maximum period as held by the FS Court is 120 days in case of both the case. It is not that, my lord, in case of commercial suit, period is 120 days, and in ordinary suit, period is 90 days. This is not that. Supreme Court has made a distinction that so far as 120 days is concerned, it is applicable to both types of suit. But in case of non-commercial suit, period of 120 days is, my lord, mandatory. But in case of, my lord, non-commercial suit, it is directory. And if your lordship wants to be heard, Father Lordship may kindly give me some more time. I will satisfy your lordship.
How much time do you require?
Now, lordship may take up them at one Friday.
Okay, heard Mr. A.K. Purkasa. On request of the learned counsel for the petitioner, let this matter be listed on 26th of June.
My lord. Over to you, Lord.
It may be granted, my lord, to rectify my defect, my lord, because the impugn order photostat copy is not
Yes, the
here.
photocopy copy. Yes,
Impugn order photostat copy is not here, but original copy is there. Okay. Leave may be granted, my lord. I may be permitted to rectify the defect, my lord.
item number 8.
8, my lord.
Heard Mr. S. A.K. learned counsel for the petitioner, who prays for allowing the petitioner to bring on record the copy of the order impugned in this CRPIO by filing an additional affidavit.
My lord.
The prayer is allowed. Let this matter when?
My lord. After vacation, my lord.
Let this matter be listed. 20 July.
Obliged.
My lord, Supreme Court
No.
decision may kindly be given to me, my lord. I will
Yes.
submit photocopy.
10, 11, same. 9, same order.
Item 10, 9, 11, 9, 10, 11, same.
Same orders. 9, 10, 11.
Item 12.
To order to return query.
My pleasure, Lordship.
Item number?
12.
Yes.
Lordship, judgment that was the petitioners of this case, and we file a petition under section 227, and the impugn order is page 17. We file a petition 151, section 151 of CPC before the Honorable Execution Court to stay the execution proceedings until disposal of the criminal misrepresentation 06/26. But the Honorable Execution Court did not state our proceedings and rejected our petition. As my lord,
Where is the
Previous-
impugn order?
page 17. 17, 17.
Yes.
Actually, my lord, the petitioners, the judgment debtors, the appellant in TA number 303/17, which is an appeal pending before the learned edition decision number 3. Preferred against the judgment 9/9/2016, passed by the learned civil judge, and TS 11/10, 2010. The said appeal was unfortunately dismissed for default on 2/9/22 under order 41 rule 17 and code of civil procedure. After respondent have initiated execution proceedings and execution case was TX 1/24 bearing upon decree TS 11/20, 10, and the petitioners have been directed to deliver possession of the suit premises. The petitioner speaks to state before the becoming the aware of the dismissal order TA 3/17 only on that date. They were about the 21/4/2026 about the dismissal order.
Before
Hence-
which court appeal is pending?
Additional decisions number 3.
Which district?
Appeal was not the limitation petition.
Yes, along with the appeal you have.
Yeah, my lord. This one additional 3.
Which district?
No.
What is the error in the impugn order?
Lordship, already we have filed a section 151 petition before the Honorable Court to stay the proceedings there. Proceedings still up to the disposal of the criminal revision limitation 06/20.
No
Mis-
criminal revision. It is civil miscase.
Sorry. Civil remedies limitation, civil limitation 6/26, which was already page number 12.
So what is the wrong in the order?
If sir execution proceeding is over and in this case is not
Heard Mr. What is your name?
MD Medhi.
Heard Miss M.D. Medhi, learned counsel for the petitioner. This application under Article 227 of the Constitution of India has been filed by the petitioners impugning the order dated 21/5/2026 passed by the Executing Court of Learned Civil Judge Senior Division, Nagaon, in title execution case number 1/2024, arising out of title suit number 11/2010. Learned counsel for the petitioner has submitted that the petitioners who are the judgment debtors in the title suit number 11/2010 have preferred an appeal against the impugned judgment and decree passed in title suit number 2010
11/2010,
11/2010.
99/2010.
What was the number of the appeal?
3/3/17.
However, one last line for us. Yes, yes. Okay, okay. Title suit number 11/2010. Stop. Said appeal has been registered as title appeal number 3/2017 before the Court of Learned Additional District Judge number 3, Nagaon. However, on 2/9/2022, the said appeal was dismissed for the default of the appellant. Stop. Learned counsel for the petitioner submits that the petitioners have filed an application under Order 41, Rule 19 for readmission of the appeal before the appellate court. However, as some delay was caused in filing of the said application, it was accompanied by an application under Section 5 of the Limitation Act 1963 for condoning the delay. Stop. The application for condonation of delay has been registered as civil miss within bracket limitation case number 6/2026, which is yet to be disposed of by the appellate court. Stop. Learned counsel for the petitioners submits that the petitioners approached the executing court by filing an application under section 151 of the Code of Civil Procedure for stay of the execution during the pendency of the civil miss limitation case number 6/2016. However, The executing court has, by the impugned order dated 21/5/2026 passed in title execution case number 1/2024, declined to grant any stay. Learned counsel for the petitioner submits that unless the execution of the unless further proceedings of the title execution case is stayed during the pendency of the civil mislimitation case number 6/2026, the purpose of filing of the appeal as well as condonation petition by the present petitioners would frustrate and the petitioners would suffer prejudice, great prejudice. Hence, she submits that the further proceedings of title execution number 1/2024 may be stayed during the pendency of the civil limitation case number 6/2026. Issue notice to the respondents. The petitioner shall take steps for issuance of notice upon the respondents by speed post as well as by usual mode within 7 days from the date of this order, returnable on 5th of August. In the meanwhile, considering the submissions made by learned counsel for the petitioner, petitioners, as discussed in the foregoing paragraphs, further proceedings of title execution case number 1/2024 shall remain stayed till next returnable date. List according.
Parliaments.
Where is the lordship? I think that put in exactly same identical manner, depending on the same manner, only division are different manner. Here this civil issues manner saying order dated 17/6/2026, by which minor amendment was sought, my lord. That has been rejected. Made ground, my lord, that due diligence could not be explained properly. Why I did not. Here is question is a little bit different. Suit was filed by us for declaration of right to intercontinental procedure. We made amendment. We brought amendment was allowed by the earlier. While allowing this, my lord, one schedule we could not, due to our left, my lord, could not mention, my lord.
What you?
The schedule A, my lord, to cancel, strike out the name of the petitioner of the defendant number 1 from document number so and so, so and so. This is to be inserted in the schedule only. And that has been rejected, my lord, by the impugned order, my lord, page 97, my lord. Relevant portion, page 97. And next page, kindly see, my lord, 98, my lord, the schedule is there. Only this portion, my lord. This down below, my lord, schedule A, my lord. This to be inserted, my lord. And the last page, my lord, you will see, page 102, my lord. The ground why it has been rejected, my lord. On bare perusal of the petition, as mentioned above, the case record revealed the plaintiff had failed to prove that in spite of due diligence, he could not introduce the amendment sought earlier. That is the only.
That is the law also.
Yes, yes, of course, of course. But here in the interestingly, my lord, kindly see my amended plain, my lord. Only in the amended plain, your lordship, that is, no, my lord, my petition will do itself. My lord, page 92. Page 92, annexure H, my lord. May I read, my lord, so small petition, my lord. 93, my lord, 90, yes, from 93, yes, from 92.
You are plaintiff.
Yes, yes, plaintiff.
We will issue notice.
Yes, of course, it has to be.
Heard Mr. A. Chaudhary, learned counsel for the petitioners. This application under Article 227 of the Constitution of India has been filed by the petitioners impugning the order dated 17/3/2026 passed by the Court of London, Civil Judge Senior Division Number 1, Kamrup Metro, in Miss J case number 549/2025 in connection with title suit number 96/2022, whereby the prayer for amendment of the plaint sought for by the present petitioners was rejected by the trial court. Issue notice to the respondent. The appellant, the petitioners shall take steps for issuance of notice upon the respondents by speed post as well as by usual mode within 7 days from the date of this order, returnable on 7th of August.
Tomorrow date is fixed for PWS, madam. And may I make this statement also, madam. Till returnable date, madam, required to be stated.
Considering the averments made in the
Para 1, madam.
instant revision petition as well as the submissions of learned counsel for the petitioner, further proceedings of title suit number 96/2022 shall remain stayed till next returnable date. Next item.
Exactly same, madam. The defendant is same, madam. Plaintiffs are different, madam.
Orders.
Orders, same, madam, order.
Same order.
Almost same, only Ms. J number is different, madam. Page 91, madam.
Ms. J number cause title of Prasab. Same order.
All right.
This revision has been preferred against the order dated 2/4/26. Lordship will find at page 82 is the import order. By this order, Lordship, page 82, the petitioner defendant has filed an application to the executive court under order 21 rule 26, right to section 151 CPC, praying for staying of the execution proceeding because another title suit number 60 of 2005 has been filed by the decree holder against the same schedule, same subject matter. And the lordship will find the relevant person. When considering this application, the learned executing court has held that order 21 rule 26 is not applicable. On the lordship will find page 83 is the finding. Page 83. After discussing the provision of order 26, order 21 rule 26, it is stated that lordship will find page 84, para 12, relevant person. Lordship got it. Upon the reading of the aforesaid provision, it appears that the petitioner can file a petition for stay of execution proceedings under the aforementioned provision when a decree is sent for execution before a particular court. Hence, where a decree is transferred to being executed, the petitioner under the aforementioned provision of law can file a petition for the stay of execution before such court to which a decree is transferred for the purpose of execution. But next para, however, the present decree is not sent for execution to this court by another court, and hence I do not find that the provision of law is sufficient to stay the execution. So, my lord, this is totally a wrong conception, my lord.
Why?
Because this is the executing court and was the trial court. So no question of sending the execution by another court to this court. So the provision is that order 21 rule 26. It is simply mentioned that I am reading, my lord. Stay of execution. The court to which a decree has been sent for execution does not mean that that should be sent by another court. That execution has been filed by the decree holder on the trial court who has passed the decree and has the right to execute it. So my lord, it is only mentioned sent for execution does not mean that that should be sent. Shall upon sufficient cause being shown, state the execution of the only consideration is that whether sufficient cause is there or not. The cause is that, my lord, and the jurisdiction in respect of the decree of the execution thereof, for an order to stay execution, or for any other order relating to the decree of execution, which might have been made by such court of first instance. This is the first instance court, my lord. And appellate court has sent it for, first appeal was rejected, dismissed. And thereafter it has been sent, that is not filed by the decree holder before the executing court, civil judge, jurisdiction number 2. This is the proper court, my lord. So the interpretation conception is totally, my lord, wrong. And lordship will find, I am the possession in land by way of purchase. And the plaintiff claiming that they did not sell the land, I was a tenant. And the second suit, they have challenged my sale deed. Lordship will find the plaintiff of the second suit file. Page 58.
No, on what ground you are seeking stay?
Stay because they are, my lord, the same subject matter, another civil suit number 60 of 2005 is pending. And I may appear.
No, but the decree in
Decree is regarding ejectment, my lord.
that is not under challenge before any court.
Decree is not challenged, but the multiplicity of suit, my lord. Because one suit land, I am claiming that I am the title holder by of purchase. My namjari is there. My Jamabandi is there. And they have now challenged subsequently. In earlier suit, they have only said that I am a tenant.
No, unless the decree is put to challenge before authority, any other authority, appropriate appellate court or under Order 21, Rule 97.
Decree is not challenged, fair animal, but
Then how execution can be stayed?
Because, my lord, because of the fact that the subject matter is sub judice, ticketing title.
No, it has already been decided by a court.
But again they file.
Again, they may file many cases.
But under section 10 CPC, my lord, section 10 CPC, there is a bar to proceed to such cases, my lord. Because execution is a process is also.
What is 10 CPC?
10 CPC is that, my lord, if there is 2 suits, one should be stayed.
But this suit has been already disposed of in.
But, my lord, title is still required to be decided, my lord.
No, but you have not put to challenge that decree before any court. How execution may be stayed?
But regarding, my lord, Rule 26 or 21, since it is held that, my lord, this provision is not applicable on this ground.
No, that may be an erroneous
observation.
But what is your ground for stay? Unless a decree is put to challenge in any form, neither before executing court nor before any appellate court, why it will be stayed?
Decree, lordship, executing court, lordship will find my application, page 72. Page 72, application before the execution court is page 72. Title execution case number
When is the next date before the executing court?
next date, next July. 20 July. 20 July, ma'am.
We are issuing notice.
Notice by issue, ma'am.
Lord Mr. Hesnath, learned counsel for the petitioner. This application under Article 227 of the Constitution of India has been filed by the petitioners, impugning the order dated 2/4/2026 passed by the Court of Learned, Civil Judge Junior Division Number 2 in title execution case number 17/2008, whereby an application filed by the present petitioners under Order 21, Rule 26. Where is your petition?
So page 72. So and also read with section 151 CPC.
Rejected by the executing court. Issue notice to the respondents. The petitioners shall take steps for issuance of notice upon the respondents by speed post as well as by usual mode within 7 days from the date of this order, returnable on return. No, before 20. When is the next day?
2020.
17th of July.
17th.
17th of July. List
Plus-
according.
From supplementary list.
May it please, your Lordship. Here, Lordship, issue is whether plaintiff is entitled to exhibit documents which are not in the list filed along with the plain and no leave was obtained to exhibit the document. So here petitioners are the defendant. Plaintiff along with their plain produce a list of documents which they have relied on. During the SBP stage, they have not sought for any leave to adduce any further, exhibit any further document. So after the PW 1, 2, and 3 are completed, plaintiff witness completed, they call one Mandal and exhibited Jamabandi. So far Jamabandi, there is no dispute because that they have already exhibited in their evidence. But they have called the Sitha book of 2 DAX. That is not in the list of documents. So on the first day, one Latmandal came and he exhibited along with other exhibited the exhibit number 8 Sitha of 1 DAG number. And the case was then fixed for further cross-examination of that PWs. But on the next day, another Mandal came. This person, PW4 doesn't come, then PW5 come. He stated that he is the in-charge Mandal of that area and he on the earlier that he was absent. So therefore, he has come and he has also exhibited another Sitha as exhibit number 12. So after that, the petitioner, the defendant, the present petitioner, file a petition under Order 13 Rule 3 for the exhibit, mentioned as the exhibit, those exhibits. But admittedly in the petition, there is not specific mention which document they want to de-exhibit. But basically I have gone through the record. So far the Jamabandi is concerned, they have already exhibited in their evidence and this other trace map they have exhibited and death certificate. So there is no dispute. So far the Sita is concerned, that is not in the listed in the list of documents. No leave was sought for. Directly they have all exhibited through the official witness PW 4 and 5. So that application was rejected by the impugn order dated
Where is the impugn order?
page 64 also. Page 64, operative portion at page 66. Paragraph number 7.
Yes,
May I read it?
please read.
On perusal of the instant petition, it appears that the ground taken for filing the instant petition are that the documents were exhibited without proper proof in accordance with law and without fulfilling the mandatory requirement of law, and they were marked inadvertently and mechanically without laying proper foundation for admissibility. Clearly, the defendant have failed to state any clear, specific, or intelligible reason for the prayer of the exhibition. The instant petition does not disclose which specific documents suffer from what defect or what proper proof was required but not furnished. It is a fundamental principle that a party must plead material fact and precise ground for the relief sought. A petition seeking to remove evidence from record must disclose the exact illegality with particulars. However, the instant petition is bereft of material particular. Further, the documents were marked as exhibit while recording the examination in chief of the aforementioned witness in the open court. However, no objection was raised then. Now, a belated challenge without assigning any cogent reason cannot be permitted.
At the time of exhibition, you did not raise any objection.
Objection.
You have not raised any objection.
Not raised the objection as per
Then-
this. So, but the case has not, the matter has not, the PW 4 and 5 has not been cross-examined as yet. So, but by this line, that was diverted from to dispute these documents during the cross-examination also, because in the last line, a belated challenge without assigning any cogent reason cannot be permitted.
Who exhibited that?
The plaintiff
Who-
has exhibited.
Now, which document you are referring to?
These two documents exhibit
That
the-
is you are now referring, even in your petition under order 13 rule
Yes,
3.
but there is no specific mention of the specific particular. I have
Yes.
seen.
How court will know which document?
No. There is a list, Lordship.
No. You have filed an application for
That is there.
rejecting the inadmissible document
Yes.
under rule 3
Yes.
of order 13.
Yes.
Unless you pinpoint the documents which
Yes.
you are saying that these are inadmissible, how court will know?
That is there, Lordship. In the petition, there is no mention specific.
Neither
mention.
you raised any objection at the time of exhibition.
Because, Lordship, in the for the relied on document of the plaintiff has been specifically mentioned in their plaint. So apart from those documents, so the other documents they cannot produce. That is page 26 is their relied on documents.
No, the documents were exhibited in evidence on affidavit or by oral.
By oral evidence.
Through official witness.
Through official.
Through official witness.
Yes.
So, and he has been cross-examined also.
Not cross-examined as yet.
Cross-examined, partly cross-examined, further cross-examination is.
Then he can raise the question of admissibility during cross-examination. Even at the time of exhibition of the document, you could have raised.
Yes.
If
But
you have,
not raised, but by this line, they are belated challenge without assigning any cogent reason. We have challenged those exhibit during cross as well as in the final argument. But impugned judgment that is given that in the paragraph 11, page 67, it is to be noted here that evidentiary value and admissibility of the document in question, if challenged properly during the final argument, shall be considered at the time of final.
so it has, the court has kept open the rightly kept
But
open that.
so far questioning about this document during the cross-examination.
You may question. The court has indicated that
Yes.
question of admissibility shall be
Argument,
considered.
but for that purpose, we have to cross-examine on that specific documents.
Yes,
So
Mr.
that-
Kalita. We'll clarify it that
If that clarification is given,
they can cross-examine because court will decide the question of admissibility at the time of final.
That is there, but respectful submission is there. What my senior friend has submitted, either I have, plaintiff have to mention it in the list of documents, or if it is not there, then they have to take leave by under order 7, rule 14. So now evidence is not over, further cross-examination is kept reserved. So my respectful submission is that, my lord, we will file an appropriate application under order 7, rule 14, under section 3, sub rule 3, and court will decide, my lord. Because, my lord, it's not that, my lord, it's not that it can be decided at the time of, my lord.
Under order
settlement of issue.
7?
It can be.
Which provision you are referring?
Order 7, rule 14, sub rule 3. Oh. You got it?
order 7, rule 14, sub rule 3.
Please read it.
It says, my lord, sub rule 3, a document which ought to be produced in court by the plaintiff when the plaintiff is presented, or to be entered in the list to be added or annexed to the plaint, but is not produced or entered accordingly, shall not, without the leave of the court, be received in evidence on his behalf at the hearing of the suit. So, my lord, my respectful submission is that, my lord, I being the plaintiff, my lord, matter is not, my lord, cross-examination is not.
No.
No.
This leave has to be taken
Prior to
prior to.
No, my lord. But that is why I am submitting, my lord. It can be raised, my lord, but at the subsequent stage also.
Show me.
Yes. In the judgment which I have placed, my lord, in that case, my lord, the application under order 7, rule 14 was submitted when the during the stage of cross-examination. And, my lord, the learned single judge of the High Court was dismissed the petition. Subsequently, division bench dismissed. Thereafter, it has come up before the Honorable Supreme Court, and Supreme Court, my lord, in paragraph 3 and 4, my lord, is important. Paragraph 3, having heard the learned counsel for the respective parties, we are unable to agree with the decision of the division bench as also the single bench, as we have been informed that the cross-examination has not yet commenced. In such a situation, we see no reason for debarring the appellant from filing the additional document in support of his claim. In such a situation, we see no reason for debarring the appellant from filing the additional document in support of his claim. We accordingly allow the appeals and set aside the order passed both by the division bench as well.
That is in facts of that case.
Yes.
No.
It is not law that
Not law.
without leave of the court.
That is why, man. I will file an application seeking leave.
When?
Seeking leave. Then, my lord, thereafter, my lord, on that before the trial court, my lord. And they will, my lord, if they want to file any objection, they will file there, my lord. Objection, my lord.
Okay.
Matter can be disposed of.
And I have a judgment of our High Court.
On that aspect, I will not make any observation.
Yes.
Because this is their revision petition.
Yes.
An observation may be made that
My contention is that before exhibiting any document, if that is not in the list, they have to take leave from the court to exhibit such document. So after exhibiting those documents, they sought for leave to exhibit the document. That is not the spirit of the
no,
CPC.
but that question may be decided by the trial court
Yes.
as and when they file such a
Yes,
petition.
yes. But I want to cite a judgment of our High
No,
Court. That is
Mr. Dekar,
yes.
which observation you are apprehending that it will harm you?
in the last part of the
Which
Pa-
para?
paragraph 9, last line. However, no objection was raised, then now a belated challenge without assigning any cogent reason cannot be permitted.
Okay. This should not influence the
Yes,
trial court.
because we can put that question.
To
So,
other,
because yes, with the other exhibit, we do not have any objection because the other are listed document.
who is the PW? PW number?
PW 4 and 5.
Heard Mr. S. Deka, the learned counsel for the petitioner. Also heard Mr. K. Kolita. Sorry. Mr. M. Dutta, learned counsel for the respondents. How many respondents are there?
All respondent here appeared. We are pro forma respondent, main respondent one.
Appearing for all the respondents. This application under Article 227 of the Constitution of India has been filed by the petitioners impugning the order dated 15/5/2026 passed by the Court of Learned Civil Judge Junior Division number 1 Golaghat in the title suit number 5/2020, whereby an objection
Petition.
whereby a petition filed by the present petitioner raising objection as regards the admissibility of certain documents which were not annexed along with the plaint at the time of filing of the plaint. Neither any leave was sought for producing those documents by the plaintiff were allowed to be exhibited by official witnesses of the plaintiff, namely Suraj Bora. Suraj Bora is
Yes, Suraj Bora Lordship.
PW
One Suraj Bora and Indrakanto Dole.
and one Sri Indrakanta Dole. Learned counsel for the petitioner fairly submits that though in the application, though in the petition filed by the present petitioners under Order 13, Rule 3 of the Code of Civil Procedure, within bracket, numbered as petition number 563/2026, comma, bracket close, praying for rejecting the documents, rejecting certain documents which were exhibited by the aforementioned official witnesses, comma, have not clearly indicated the documents against which such objection has been raised, comma, however, comma, he submits that it is apparent that any document which was not mentioned in the list of documents filed by the plaintiff would come in the purview of the objection raised by the present petitioners. He further submits that though by the impugned order the trial court has observed that the question of admissibility of the documents in question as well as evidentiary value thereof shall be considered at the time of final disposal of the suit. However, in paragraph number 9 of the impugned order, an observation was made by the trial court that as no objection was raised during the recording of examination in chief of the aforementioned witnesses in the open court, the petitioners cannot raise such objection at a belated stage, and as such same cannot be permitted. Stop. He submits that the trial court has already, by making such an observation, debarred the petitioners from raising objection as regards admissibility at a later stage, and it would greatly prejudice the present petitioners, as the cross-examination of the witnesses who have exhibited the unlisted documents is yet to be completed. He therefore submits that the observations made by the he therefore submits that a directions may be direction may be given by this court that the observations made in paragraph 9 of the impugned order may not have any bearing at the time of deciding the admissibility of the documents questioned by the present petitioners
During cross-examination.
during cross-examination. On the other hand, Mr. M. Datta has also fairly submitted that the official witnesses have exhibited certain documents which were not originally mentioned in the plaint or list of documents. However, he submits that the plaintiff is not precluded from filing an application under Order 7 Rule 14 within bracket 3 of the CPC at a belated stage. In support of his submission, he has cited a ruling of the Apex Court in the case of Kapil Kumar Sharma versus Lalit Kumar Sharma in another, reported in 2013 for 14 SCC 612. I have considered the submissions made by learned counsel for both sides and have gone through the materials available on record. I have also gone through the rulings cited by learned counsel in support of their respective submissions. On perusal of the impugned order, it appears that the trial court has kept open the question regarding admissibility of documents against which objection has been raised by the present petitioner, to be decided at the time of final disposal of the suit. However, I find logic in the submissions made by learned counsel for the petitioners that if same is to be done, then trial court may not, then the observation made by the trial court in paragraph number 9 of the impugned order must not have a bearing on such determination. As such, this court directs that the observation made by the trial court in paragraph number 9 of the impugned order dated 15/5/2026, passed in title suit number 5/2022-20 shall not have any bearing on the final adjudication regarding the question of admissibility of the documents which the petitioners are challenging. The petitioners are also at liberty to raise the said objection during the cross-examination of the official witnesses. Stop. On the other hand, the if any application under Order 7 Rule 14 of the CPC is filed by the plaintiff / respondents before the trial court, same shall be considered by the trial court on its own merit. With above observation, this civil revision petition is disposed of.
Obliged.
What is this?
Restoration. So Talukdar was here, Lordship. Last order, Lordship asked him a pointed question whether
You are opposing?
because they have given all the reasons that the council did not appear and all that, Lordship. So that's why the question was put to him. And they have not.
Yes, Mr. Talukdar.
Petition from the.
Lordship, this is an application for restoration of the appeal, which was dismissed for non-prosecution, Lordship.
When it was dismissed?
It was dismissed on 23/7/18, 2018,
Long back.
Lordship. And there was a delay of 69 days in filing restoration petition, and that was allowed, Lordship.
What is the ground for default?
For the fault, and in fact, there is fault on the part of the earlier council, Lordship. I have explained it from, Lordship, kindly see at page 3 from paragraph 4 onwards, Lordship, up to paragraph 13, Lordship.
Why have you filed the appeal seeking enhancement?
Enhancement, Lordship. Lordship, last question, Lordship was pleased to direct us to produce some authorities in this regard.
Yes, what authorities?
High Court.
I got
What authority?
division bench judgment, Lordship.
What is this?
Lordship, it is also a case dismissed for default, Lordship. For
Or
the fault of the
lawyer?
lawyer, Lordship. May I read, Lordship, from paragraph 1?
No, paragraph 6 only.
6. Lordship, in the instant case, the petitioner's case is squarely covered by the aforesaid pronouncements of the Supreme Court. The petitioner also comes from a far-flung village of district of North Lakhimpur, and he took steps to come to Gauhati all the way from distant village in the district of Lakhimpur and filed an application on coming to know about the fate of his appeal from his lawyer, which was dismissed on account of his lawyer's laches. He should not be penalized for the fault of his lawyer. Being a villager, he may not be aware of the technicalities of procedural laws. In your opinion, it is preeminently a fit case where the appeal should be restored to file, which we hereby do.
How much delay was there?
There was a delay of 69 days.
That has been condoned.
Condoned, Lordship.
Yes, Ms.
Lordship,
Major.
Lordship,
Only
there are similar cases, similar facts and circumstances of the cases. You, Lordship, allowed the delay of 499 days and further allowed the restoration petition, and ultimately judgment was delivered by Lordship. And the amount
No,
enhanced.
that is a different case. Let us.
case to case. Lordship, here, Lordship will see that the MSc case was of 2008, Lordship. And we are in 26 now, Lordship. Till when the case was dismissed, that time itself, it was 10 years past, Lordship. Who is going to bear the interest part, Lordship?
They will not get interest under such, even if the appeal is restored and even if they get a favorable order, this has to be pointed out because there is a lapse on their part.
Yeah, Lordship, almost 20 years.
But
because-
regarding restoration, what objection you have?
Lordship, as per 4119, Lordship, there has to be a cost. The court shall readmit the appeal on such term as to cost. Cost is to be imposed. And Lordship will, he has to agree, Lordship, that when the case is heard, Lordship, he will himself point out that interest will not be applicable.
No,
That much
No,
footnote should be there.
you may not get the interest for the period,
For a short period of 69 days, Lordship.
No,
not 16.
There is delay
it is
in filing restoration of
10,
69 days delay in filing restoration petition.
18 years. Delay has already been condoned, Lordship. Delay is not here. Here, the petition is of restoration and the MSc case was of 2008. Now it is 18 years, Lordship. Until the hearing takes place, another 2 years will go. 20 years.
Yes, we do not know what
Yes.
their appeal may be dismissed also.
That is different issue, Lordship. But then we have to be positive. He has filed us for something, maybe enhancement of 10,000, but still there will be enhancement, Lordship. So the interest, Lordship, will make an observation that they will not get the interest, Lordship, for all this time.
Heard Mr. M. Talukdar, the learned counsel for the applicant. Also heard Ms. R.D. Majumdar, learned counsel for the respondent number 1, insurance company. This interlocutory application has been filed by the applicant / claimant praying for readmission of MAC appeal number 40/2012, which was dismissed for default by order dated 23/7/2018 of a coordinate bench of this court. Learned counsel for the petitioners, learned counsel for the applicants has submitted that in preferring the present petition application for restoration, for readmission of the appeal, there was a delay of 69 days. However, the said delay has been condoned by this court in a connected interlocutory application. He submits that it is due to lapse committed by the engaged counsel or the petition applicants who failed to appear before this court when the matter was called on for hearing on several occasions. And finally, on 23/7/2018, he submits that the petitioner is physically suffering from physical disability and financial crisis, and he is a resident of district of Kachar, and therefore he was not in a position to come to Gauhati to engage another set of counsel to pursue the instant application for readmission. He submits that it is a settled proposition of law that a poor litigant should not suffer for default or carelessness or negligence of his engaged counsel in pursuing the matter for which he was engaged. He submits in support of his submission. He has cited a ruling of full bench, a ruling of a division bench of this court in the case of Binod Barua versus Ratul Chandra Goswami, reported in AIR 1987 AIR within bracket GAU 7. He submits that unless the connected MAC appeal number 40/2012 is restored, the petitioner would suffer, the applicant would suffer great prejudice due to no fault on his part. On the other hand, learned counsel for the respondent insurance company has opposed the readmission of the readmission of MAC appeal number 40/2012, mainly on the ground of old pendency of the original application. She submits that
The other parties are not made parties.
she also submits that who are not made parties.
That's it.
No.
No,
Strike- strike
the
out.
other part is, has already been struck off, Lordship.
He submits that in the event the petition is allowed, the counsel for the petition applicant should fairly give an undertaking that in the event of allowing of the connected appeal number MAC number 40/2012, the applicant/appellant would not claim interest over the enhanced compensation if awarded for the period. For which period?
Till today,
For the period
from 2008 till today,
from
22/6.
2008 till the allowing of the aforesaid appeal.
6/2020.
So I have considered the submissions made by learned counsel for the both sides and have gone through the materials available on record. I have also considered the ruling cited by learned counsel for the applicant in support of his contention. It appears where is the dismissal for default order?
At page 8 and 9. Yeah, fine.
It appears that the connected MAC appeal, that is MAC appeal number 40/2012, was filed in the year 2012, impugning a judgment and award of the Motor Accident Claims Tribunal, which was passed on
3/6/2011, Lordship.
3/6/2011, and same was dismissed for default when none had appeared when the matter was called on for hearing on 23/7/2018.
And it is their own admission. Earlier also he did not appear at the council.
Lordship, appeal was filed in time. In fact, Lordship, 2011 judgment was delivered by the Learned Tribunal, and appeal was filed in the year 2012, Lordship.
The present applicant have attributed the entire negligence to their earlier engaged counsel. The proposition of law regarding as to whether for the default or carelessness or negligence of a lawyer should the litigant be made to suffer has been settled by the apex court in several of its judgments. The ruling cited by the learned counsel for the petitioner of this court in the case of Binod Barua versus Ratul Chandra Goswami Supra also refers to such decisions of the apex court, where it was observed by the apex court that a poor litigant should not be penalized for fault of his lawyer. So in the instant case, the litigant, the petitioner who suffers from a physical disability, hails from Kachar district, and it is apparent that when the appeal was called on for hearing on 23/7/2018, the engaged counsel for the applicant did not appear before the court. Hence, this court is of considered opinion that the present applicant may not be made to suffer due to the negligence of his engaged counsel. As such, this application for readmission of MSc Appeal number 40/2012 is allowed. The registry is directed to list the connected appeal for admission on 29 July 2026. As regards the submissions regarding claim of interest during the period from date of filing of the appeal till disposal of the connected appeal in the event of passing of a favorable order in favor of the present applicant is concerned, this court is of considered opinion that the said question is premature at this stage. The said plea may be raised by the insurance company during consideration of the appeal at an appropriate stage. With the above observation, this interlocutory application is accordingly disposed of.
It may be so.
The petitioner, the learned counsel for the appellant is requested to furnish a copy of memo of appeal to the learned counsel for the respondent insurance company. Yes.
Item 23 and 24.
Yes.
It is Lordship. Lordship, office note dated 14/5/2026.
What it says.
Lordship, steps was taken usual post and register post. And the unserved notice in respect of register post is returned with, the person is not.
No such person. Then what is to be done?
Lordship, the usual process was taken, that was not returned. We can report, Lordship.
You want us to wait?
What, Lordship?
Heard Mr.
A. Hussain.
A. Hussain, learned counsel for the appellants. None has appeared for the respondent number 3. It appears from office note dated 14/5/2026. Let service report in respect of notice issued to respondent number 2 through speed post has returned with postal remarks. No such person in the given address. However, the service report in respect of notice is sent to the said respondent by usual mode is still awaited. Let the service report be further awaited. Let this matter be listed 21 July.
Okay, sir.
Item 25.
Heard Mr. H. Gupta, learned counsel for the petitioner applicants submitting on behalf of Ms. R. Devi, learned Central Government Council. 25.
Yes. That's it. I was informed by the NKS Council of Railway Department that her brother has been suddenly expired.
Yes.
So they wanted to have adjourned.
You are for?
I'm for the respondent here also.
You should come this side.
Yeah.
Otherwise,
He was here, that's why.
he is also responding. Kalika. CGC that she is in bereavement and therefore he prays for an adjournment for the day. Also Mr. T.R. Gogoi, learned counsel for respondent number 2, as well as Mr. A.C. What is your name?
P. Medina.
P. Medhi, appearing for respondent number 1, who do not have any objection to the prayer for adjournment. Hence, the prayer is allowed. Let this matter be listed 31st of July.
Item 26.
26, Lordship, as per office note dated 8/5/26, Lordship, respondent number 1 and 2 duly served. Unserved notice of respondent 5 received back, not found, out of station, returned to sender, flag A. Then, Lordship, office note, the next office note, Lordship, unserved notice on respondent 6 has been received back with postal remark insufficient address, returned to sender. Postal tracking report of 3, 4, and 7.
For 1 to 4, 1, 2, 3, 4.
I'm for 5 and 7.
So only 6 is remaining.
Lordship, 6 can be, he is a driver, Lordship. He can be striked out because we can go for the hearing of the description.
Heard Miss R.D. Majumdar, learned counsel for the appellant.
It can be waived, Lordship.
Also heard Mr. A. Bhattacharya, appearing for respondent number 1 to 4, as well as Mr.
Yeah,
A. Ali, appearing for respondent number 7,
no, 5 and 7.
5 and 7. Learned counsel for the appellant submits that considering the contentions raised by the appellant in this appeal, the presence of respondent number 6 may not be necessary in this appeal, and hence she has prayed for striking out the name of the respondent number 6. The prayer is allowed. The names of respondent number 6 may be struck out. Since the record of the concerned motor accident case has been received, this appeal is ready for hearing. Place this matter for hearing 15th of September.
September.
Item 27, Population Code. May I please? Look, in respect of the main MSc appeal, Miller, there is a office note of 17.6, Miller. The ID cards of respondent 1 to 5 and 7 are awaited. Answer notice of respondent number 6 has been received back with a postal remark left, and LCR is awaited, Miller.
You are appearing for whom?
May it please your lordship, in this case, we have the instruction to file instruction on behalf of the claimants respondent number 1 to 5.
1 to 5.
1 to 5 time to file our
Wakalat number. Okay. You?
I'm appearing for the OP number, opposite party numbers 6 and 7.
Oh, service is complete.
Great. Okay.
Today I filed the Wakalat number.
You have already filed.
No, today I.
You'll be filing. Heard Mr. P. Hajorika, learned counsel for the appellant. Also heard Mr. What is your name?
Jyoti Prakash Talukdar.
J.P. Talukdar, who submits that he has been instructed by respondent number 1 to 5 to appear on their behalf, and he would be filing his Wakalatnama shortly. Also heard Miss
Sabitri Guru.
S. Guru, learned counsel, who submits that she has been instructed by respondent number 6 and 7 to appear on their behalf, and she also seeks some time to file Wakalatnama in this case. The appearance of parties in this appeal is complete. However, it appears that the records of MSc case number 61/19 have not yet been received. Registry to issue reminder for hearing. List this matter again on 31st of July.
The IML lordship will find that notice was issued, there is a stay petition. Since all the parties have been represented, that will be considered.
You pay 50%.
There is a difficulty. We'll submit, because we have taken the ground that the person fallen from a tree. He was admitted in the highest hospital. After demise of 30 days, the SR was lost.
There was no accident.
No, there is no vehicle involved. We'll deposit some amount that may not be released to.
You will be filing any objection?
I have filed 50%. I will be filing IR for 50%.
No, you file objection against this. Let them file objection.
Sure. We'll deposit subject to deposit will that stay will be granted. Let them file an application for withdrawal.
Okay. Heard Mr. P. Hajorika, learned counsel for the applicant. Also heard Mr. Your name, you have to repeat again.
JP Jyoti Prakash Talukdar.
JP Talukdar, Learned Counsel for respondent number 1 to 5, as well as Miss S. Gurung, appearing for respondent number 6 and 7. This interlocutory application has been filed by the insurance company, praying for stay of execution of the judgment and award dated 17/2/2026, passed by the Motor Accident Claims Tribunal Nalbari in MAC case number 61/2019, which has been impugned in the connected MAC appeal number 242/2026. The Learned Counsel for the respondents submits that they don't have any objection if the applicant is directed to deposit 50% of the awarded amount as a condition for grant of stay. Stop. In view of the submissions made by Learned Counsel for the parties, this interlocutory application is allowed. The execution of the impugned judgment and award dated 17/2/2026, passed in MSC case number 61/2019, is hereby stayed during the pendency of the connected MAC appeal number 242/2026, subject to deposit of 50% of the awarded amount by the applicant insurance company before the registry of this court within a period of 6 weeks from the date of this order. This interlocutory application is accordingly disposed of.
Obliged.
Item 28.
May it pleases your lordship. Lordship, as per office note dated 18/6/26, respondent number 1 notice was received by brother. 3 notice personally received, and that is in service report. No AD and unserved notice or service report of respondent 2 and 4 has arrived as yet. Lordship, AD doesn't come. We had taken step by step speed post. Registry is supposed to give the postal tracking report.
Yes, heard Miss Adi Majumdar, Learned Counsel for the applicants, on perusal of the office note dated 18/6/2026, it appears that the notice issued to respondent number 1 and 3 have been duly served on them. However, as regards respondent number 2 and 4, the service report is awaited. Stop. The registry is directed to place the postal track consignment report of notices issued to respondent number 2 and 4 by speed post before this court on the next date fixed. Let this matter be listed. 22nd July.
Highly obliged.
Item 29.
May I please lodge. This is an application under section 5 of the Limitation Act.
But lordship, I pray for further some time for filing the objection.
Written objection.
Lot.
It's the second occasion.
That's true. That's true. Lordship, kindly keep it after the vacation.
Heard Mr. S.D. Purkas, the Learned Counsel for the petitioners. Also heard Mr. D. Nath, Learned Senior Government Counsel, appearing for all the respondents.
Not
all the respondents.
All the respondents who prays for some more time for filing written objection against the prayer for condemnation of delay. The prayer is allowed. Let this matter be listed. 23rd of July.
Item 30 also will be the same, I think.
same now.
30 same order.
Lordship.
23rd July.
21st.
23/7.
Item 31.
My lord, we have filed in IA for vacation of the interim stay granted by your lordship on 16/11/2018. My lord, the incident occurred in the year 2016. That is on 6/3/2016. Kindly see page 5, para 2 of our IA, that is vacation petition, my lord. And the learned MSc tribunal awarded ₹14,80,000. And my husband was at that time only 40 years of age. We filed case in 2016 after few months. Till today, my lord, 10 years have elapsed, but not a single rupee has been paid by the insurance company. Now they have taken the plea that the notice upon one respondent is not received back. Now, one thing their claim is that the vehicle had no permit. Now, my lord, Supreme Court is very much clear. Kindly say, my lord. So, is it?
I have to stay.
So, since last.
Let me see appeal.
Since last 10 years, this widow is getting nothing. And kindly see this, we have given the judgment of the Honorable Supreme Court in case of Nagendra versus the New India Insurance Company. Kindly see para 8, 9 and 10.
You have deposited 50%.
No, Lordship,
No
there was a
fund.
full stay. Actually, what the tribunal did, your Lordship, was it has directed the owner to, they are saying they have not got anything, but owner has not filed any appeal, owner is not appearing here also. He was directed to pay 50% and 50% by the insurance company and then to recover. So we filed the appeal. How the time taken in how is it our fault, Lordship, if the party is not appearing? And the service was given, Lordship, that person, I have the report, that person is not found. And then today I'm going to make a prayer that I'll do newspaper publication and let it be listed in July. I do not have, let it be heard. I do not have any issue with that. I'm ready. If without the owner also, Lordship hears the matter, it is fine with me. But the thing is, they are saying they did not get anything. Lordship, in the judgment itself, I think they have also annexed that judgment in their eye. It is mentioned that 50% will be paid by the. I am of view that at least 50% of amount is to be borne by the insurance company, and the next 50% would be borne by owner of the vehicle directly. In fact, we are not liable, totally not liable. Permit violation, Lordship. Judgments are there. Today, we are not doing the hearing. Lordship,
Kindly see that judgment. Is Apex Court says permit is totally immaterial. The insurance company will pay, then they would recover from the same, from the owner. Now, 50% has been asked to pay by them. But out of their 50%, if that amount is 50% is given to us, since 10 years we have got nothing. So, Lordship, kindly appreciate our condition.
Who is the appellant?
Well,
we are the appellant. It is their their respondent, and they are saying for 10 years they have not gone for execution or they have not filed any petition also.
because stay was there. Stay was there. How can
They also there is a stay, Lordship. They are
That is
alleging.
right.
Allegation doesn't help, Lordship.
No, that there is a stay. That is why you have filed this vacation petition. So our prayer is this: kindly vacate this and ask the insurance company to pay their 50%. What amount was asked to pay by the insurance company, their 50% may be given to us immediately. So for the owner's share is concerned, that we will see later on. But for the time being, let me leave. Let me leave. I am a widow. Since 10 years, I have got nothing.
10 years you have not filed any application
Because
against the stay.
my earlier lawyer did not take any interest. That does not mean that the client will suffer. Lordship, just a few times ago, your Lordship has passed order. Due to the laches and negligence, lawyers cannot.
Then I'll file objection.
Okay,
I have a right to file objection.
you file objection.
And in the meantime,
And in the meantime, you take steps for publication of notice in newspaper.
I have filed this IS, that is on My learned friend has got so many time, but she has not filed any objection.
No,
Lordship,
we have,
appeal in 2018.
we have to expedite the
Yes. the hearing,
appeal
yes.
hearing. Because the
Some amount should be given to us.
point you are raising,
Some amount should be given to us because I'm a widow. Kindly
why
consider.
some amount? You take whatever is to
That is,
which you are entitled.
that I
Yes, I'm
understand, but
ready to give full amount, but after proper
Let,
adjudication.
let the hearing be done.
a short date may can be
And
fixed.
Miss R.D. Majumdar, learned counsel for the appellant, appeal. Also, Mr. M.U. Mahmood, learned counsel for respondent number 1 to 3. On perusal of the office note
Dated 18/6.
dated 24 4/2026, it appears that no affidavit as regards the sea service upon respondent number 4 and 5 has been filed by the
Because if I have the report,
appellant. However, learned counsel for the appellant submits that the service could not be affected by dusty mode on respondent number 4 and 5.
because
And-
Lordship,
And
they were
therefore,
not available.
therefore she prays for allowing the appellant to take steps for issuance of notice upon respondent number 4 and 5 by substituted mode of publication of the notice in the newspaper. The prayer is allowed. The appellant shall take steps for publication of the notice to the respondent number 4 and 5 in
Assamese daily, Lordship.
one Assamese daily newspaper, which has wide circulation in the
Group and Borpeta.
last known address of the respondent number 4 and 5. The date of notice to be mentioned in the July deal.
July Lordship, it will be less because holidays are coming. We'll have to take steps to registry in this. So Lordship, it has to
It
be.
is in High Court, not in papers office.
No, Lordship.
Papers,
Lordship, I
papers
don't
office is
know my
open.
senior knows it or not. We have to
Yes.
take the notices
Be-
signature from the High Court. Then only we can send it to the newspaper.
Mentioned in the notice shall be 14th of August. List accordingly. In IA Likhibo, heard Mr. M.U. Mahmood, learned counsel for the applicant, also heard Mr. R.D. Majumdar, learned counsel for the respondent, who seeks leave of this court to file a written objection against the application made by the applicant for vacation of the stay orders. Prayer is allowed. Let this matter be listed along with the connected MAC appeal on 14th of August.
Hello,
On that day, our interim prayer may be considered, madam. At least 50% as per section 173.
That will be open to.
My lord, actually, kindly.
That day you make prayer. Let us see what happens on that day.
In this manner, more than 10 years have elapsed. That is why, my lord, I
No,
have.
we'll take into consideration everything.
It
Let
is-
her file objection.
Item 32.
I have for my lord withdrawal of 50% of the deposit amount. My lord, I have checked the office note, my lord, which shows that owner already expired, my. Flag market.
Yes, Ms. Chaudhary. You have any objection?
Objection, Lordship, in this regard. First of all, Lordship, the driving license was fake, Lordship. That is reflected in the police report also, Lordship. And against that, police has also filed an FIR, Lordship, against the driver, Lordship. That fake license, Lordship. Secondly, Lordship, that That as per
Owner may not be knowing whether it is fake or not.
lordship. That is when owner will, before your lordship, then only lordship may hear the matter, lordship. At this stage, lordship. I
Owner
think,
expired.
so far as the secondly, lordship, the alleged offending vehicle is a Bolero pickup vehicle, lordship. And it's a goods carrying commercial vehicle. But what happened, lordship, as per police report, lordship, the occupants, they carried 11 numbers of occupants. Whereas, lordship, policy allowed 2+1 coverage, lordship. So under that circumstance, there is a violation of policy condition, lordship. Therefore, I pray that lordship at this stage at least may not be released, lordship. Because so far as office note is concerned, lordship, office note, as per office note, lordship, unserved notice of response number 4 has been received back. Office note dated 17/6/26, lordship.
Now, what has happened to the main appeal?
Yes, that is regarding service, lordship, 17/6/26, office note, lordship. We have taken steps as per direction of this honorable court, lordship. And the report is that, lordship, unserved notice of response number 4 has been received back with postal remark, no such person.
Who is respondent number 4?
The driver.
4 is the driver, lordship.
5?
5 is the
Five is
winner,
the-
she expired. ma'am.
Yes, I may be allowed to take lordship sometime so that I can file an appropriate application for substitution, lordship. And this regarding response number 4, lordship, I may be allowed to take fresh steps, lordship, with correct address. Because I have seen, lordship, two addresses are sometimes in different, lordship. So with correct address, I may be allowed to take speed post, lordship.
In appeal.
No, my lord,
Response number 4.
in the appeal itself, my lord, the notice was not issued upon the respondent, my lord, the applicant here in my lord. Subsequently, after waiting several years, my lord, yes, she came to know about the proceeding, my lord. And on her own, my lord, without receipt of the notice, she has appeared and filed this application, my lord. And my lord, I have stated the hardship I am facing, my lord, the petition applicant number 1. My lord. She is widow lady having 2 minor children, my lord.
You file in, if you want to file any objection.
Yes, lordship.
Make appeal, heard Miss M. Chaudhary, learned counsel for the appellant. Also heard Mr. J. Laskar, appearing for respondent number
1, 2, and 3.
1, 2, and 3. On perusal of the office note dated 17/6/2026, it appears that respondent number 4, notice issued to respondent number 4 has been received back with an endorsement, no such person, and notice issued to respondent number 5 has been received back with an endorsement, addressee deceased. Stop. Learned counsel for the appellant submits that in view of the office note dated 17/6/2026, some time may be granted to the appellant to find out alternative address of the respondent number 4, as well as to take instruction as regards taking necessary steps with regard to the deceased respondent number 5. The prayer is allowed. Let this matter be listed 5th of August. In IA, heard Mr. J. Laskar, learned counsel for the applicant. Also heard Ms. M. Chaudhary, learned counsel for the respondent insurance company, who submits that since there has been violation of policy condition in the instant case, the insurance company intends to file a written objection against the interlocutory application filed by the present petitioners and seeks some time for the same. Prayer is allowed. Let this matter be listed on 5th of August.
Stop, please.
Item 34.
May I please, Lord?
Yes.
Lordship, on the last occasion, I have apprised this court that parties are ready to settle the issue amicably in mediation.
May I please, Your Honor? Your Honor, my party is not at all agreeing for mediation, Your Honor. I had to talk yesterday night.
Not agree.
No.
Whom to believe?
If respondents are not agreeing, then we have to go ahead with the hearing.
Yes.
They are not agreeing.
My lord, we have to
Then it has to be heard.
heard.
Though heard Mr. D. Majumdar, learned counsel for the appellants. Also on Miss, what is her name?
S. H. Chaudhary.
S. A. Chaudhary, learned counsel for the respondents. Though on last occasion, learned counsel for the appellants has informed this court that there is a possibility of amicable settlement, however, learned counsel for respondent has submitted that she has been informed by the respondent side that they are not ready to go for an amicable settlement and submits that the appeal may be decided on merits. Since this appeal is ready for hearing, place the same for hearing on 15th of September.
Like,
No problem.
Release
Release away.
For reasons mentioned in the judgment, this appeal is allowed and the impugn order in judgment is set aside. Yes.
Yes, may I please, your lordship, in this matter, your lordship has heard us on dated 34/2026. Wherein your lordship has made some observation as per para number 3 of the order.
Where is the order?
Para number 3 of the order dated 34/2026.
Order. Order dated?
Order dated 34/2026. Para
Yes.
number 3.
Yes.
So your lordship has heard us at length, and however, lordship, this was
Okay, now what
we
is the
argued again
submission?
on the question of maintainability. But how lordship, at this point, lordship, we have filed an application for amendment of the prior portion, lordship. We have filed an IA since the matter was not disposed of. So we have filed an IA since there are some clerical mistake in the petition.
Who is for the other side?
I'm here, lordship.
Zoram Chana,
My
you
lord.
have any difficulty, any submission regarding the prayer for adjournment and prayer for amendment,
Amendment, lordship.
related stage?
The matter has now already been fully heard, my lord, to my humble understanding.
Lordship,
Even
it's
as-
just a clerical error, and moreover, we have invoked the inherent power of this honorable court. And
As far as the amendment sought for, my lord, is concerned, I do not have any much objection.
Okay. Then let them file the amended petition.
My lord, my lord. In the meantime, my lord, since the matter has still now not been released, my lordship, so I think your lordship would continue to take it up.
But hearing such matters on VC is difficult.
My lord.
But I have not kept it part heard.
No, Lordship, but however, though no mentioning of the release of the
So
matter.
I'll release it
has
from
been-
part heard, along your petition.
Yes, Your Lordship.
Yes. Heard. Miss H.
H.
Lalman
Lalman
Swamy, learned counsel for the applicant. Also heard Mr. C. Zoran Chana, learned senior counsel come. You are also public prosecutor, Mr.
My
Zoran
lord,
Chana.
here I stand as a prosecutor, as. No, my lord, I'm a
Oh.
counsel for the MRB, my lord, sorry.
The
For?
bank respondent, that is the complainant, Lordship.
The
The
PP,
PP is, I don't
this
know.
is Linda Fumble.
C. Zoran Chana, learned senior counsel, appearing for respondent number 1. This interlocutory application has been filed by the petitioner
Yes, Your Lordship, the petitioner.
Under section 528 of BNSS, praying for allowing the petitioner to amend the instant revision petition for rectifying certain typographical and clerical errors which have crept in the prayer portion of the said petition. The prayer is not objected to by the learned counsel for the other side. Hence, same is allowed. The petitioner is allowed to submit the rectified / amended revision petition before the next date fix. It also appears that the connected revision petition number 4, though it was heard at length by however, by order dated 30/4/2026, a query was posed by this court as to whether the revision petition is barred by section 442 within bracket 4 of PNSS 2023. And as the said question was not addressed by any of the counsel at that point of time, the matter was fixed for hearing again. Though it also appears that though the matter was not kept as part heard, however, a coordinate bench of this court, by its order dated 12/5/2026, directed it to be listed before the undersigned within bracket write my name, bracket stop. It is clarified herein that the matter was not kept as part heard by this court. However, so as to avoid any confusion in this regards, this matter is released to be part heard, released from part heard, and registry may list the same before any bench available before any appropriate bench available before the available in the Aizol bench of the Gauhati High Court. List this matter again on should I give a date, fixed date?
No, Lordship, it may be
Yeah,
listed
yeah.
after 2 weeks, after vacation, Lordship. if
After 2
that
weeks,
possible
on a
is
date to be
there.
fixed
Yeah.
by registry.
Mm.
One would common order in CRPIO in this order will be common. List accordingly.
Mm. Deeply obliged.
Obliged, Your Lordship.
Major options. My lord, the next date is on 21st of July.
Our court ki tya kari. We'll give a date before that date
My lord, for my lord appearance.
for service of notice.
In the meantime, I'll pray that my lord, the further proceedings in the suit
Oh.
may be stayed.
We are fixing it. Therefore, I was inquiring about date. We will fix a date before next date before the
The
trial court.
Then let it be
So-
mentioned in the order that the prayer for the interim my lord order will be considered on that day.
Yes, yes.
Otherwise, my lord, it will be considered that this interim order has become infructuous and being refused by the
No,
court.
no.
Then, my lord, if your lordship kindly goes to the genesis of this case and allow me to tell my lord,
No,
this
but
is a very, very fit case where my lord.
let the other side appears.
No, my lord, let the other side appear. Anyway, they will appear, but kindly consider this aspect of the matter, my lord. I had litigated for that for that plot of land from the trial court up to this court in second appeal, my lord. My lord, the other side, they had withdrawn the second appeal. I had, my lord, won throughout the litigations, my lord. Thereafter, my lord, after withdrawing the second appeal, they had vacated the suit land. I went there, I am residing there with my home and hearth. Today, they are disposing me, my lord, on the strength of this order, and they are coming up saying that, my lord, because, my lord, that they had, and I have entered, that I have, my lord, disposed them without due process of law. And lordship should kindly see, my lord, that they say in the plain that the entire alleged action, even if it is taken to be correct, my lord, on the night of 30th of January. And if your lordship kindly comes to the last page of this, my lord, petition, I have given, my lord, that the suit was filed on the 1st of August, my lord. That is beyond 6 months. And, my lord, if it is beyond 6 months, my lord, my lord, the question of, my lord, entertaining the suit under the specific relief act does not arise, my lord. Because the limitation for a specific suit under specific relief act is only for 6 months, my lord.
Heard Mr. G. Chaudhary, learned counsel for the petitioner, learned counsel for the applicants. This application under Article 227 of the Constitution of India has been filed by the applicants, by the petitioner, under impugning the order dated 28/4/2026, passed by the Court of Learned Civil Judge Senior Division, Sonitpur, Tejpur, in Misja case number 67/2023, arising out of title suit number 62/2023, whereby the application filed by the present petitioner. You prayed for rejection of the plaint.
Yes, my lord. I prayed for rejection of the plaint. On that point, my lord, it is barred by law, my lord. That was not considered. And secondly, what was not considered is, my lord, because lordship is aware that for the purpose of, my lord, considering a petition under Order 7, Rule 11, the court can also see whether there is any crafty pleadings involved. Now, if your lordship kindly see the pleadings which is there in the suit, my lord, they have brought this date on 30th of January, my lord, just to show and to bring it within the within that, my lord, 6 months, even though they have failed on that, because the document shows that it was filed on the 1st. Now, my lord, kindly consider this aspect that if anybody disposes, my lord, by force on a particular day, will he wait for 6 months to come to the court, my lord, without doing anything? And there is nothing on record. And moreover, my lord, the pleadings which are there, my lord, the pleadings are akin to the earlier pleadings of title suit number 32 of 94, my lord. He is taking me back again to the title suit number 32 of 94, where, my lord, which was decided, my lord, in my favor by this High Court, my lord.
Prayer for rejection of plaint was rejected by the trial court. Issue notice to the respondent. The petitioner shall take steps for issuance of notice upon the respondents by speed post as well as by usual mode within 7 days from the date of this order, returnable on 70. There it is 20th.
There is 21st.
17th of July. The prayer for interim relief shall be considered after due service of notice on the respondents.
On the next date, let it be on the next date, because if it is served, it is not served, my lord. Who
You
knows?
take
Because
steps.
I am suffering, my lord. I am suffering, my lord. I am not being now disentitled to the fruits of my lord decree, which I have received from a long litigation, my lord. And thereafter now,
No,
by way of this fruit,
purpose of-
again, I am again taking back, I am again taken back, my lord, to my lord, give evidence to my lord, face a suit, my lord, on the same grounds, on the same issues, by which, my lord, I have won the case since 94, my lord.
We are giving one option. If that day notice, if you take steps properly,
Now, take steps, I will take, my lord. That's no question in that.
then notice.
Let it be, let by the further proceedings be stated, because the palpableness
No, no.
illegality I am showing before your lordship, my lord.
Now
Only consider that aspect of the matter.
you will not be harmed because next date is on 21st. The proceeding will become
Taken up again on 21st.
21st only.
21st, yes, my lord.
So therefore we are fixing date on 16th.
Just don't say, my lord, that, my lord, after due service. So then when due service?
Due service of notice
Let it be, my lord.
slash next day.
Yes, my lord.
Slash next day.
Item 45.
Yes.
Yeah, please, my lord. But this IA I have filed for withdrawal of the 50% amount deposited by the insurance company.
Any objection?
No objection, but that cannot be recorded.
Okay. Heard. Mr. A.K. Gupta, learned counsel for the your submission is recorded in the live streaming. Learned counsel for the petitioner. Also are Mr. A. Bhattacharya, learned counsel for the respondent insurance company. This application, this interlocutory application has been filed by the applicants slash claimants praying for release of the 50% of the awarded amount which was deposited by the opposite party number one insurance company in pursuant to the order dated 2/5/2025 passed in IA number, IA civil number
2525.
2525, passed in IA civil number 1286/2025 as a condition for grant of stay of the execution of the impugned judgment and award in the connected MAC appeal number 156/2025. After considering the averments made in this interlocutory application as well as facts and circumstances of this case, the prayer is allowed. The registry is directed to release the amount, 50% of the awarded amount, which was deposited by the respondent insurance company in pursuant to the directions of this court, comma, to the present applicants slash claimants after proper verification. This interlocutory application is accordingly disposed of. What is the status of the MAC appeal?
Well, my lord, notice was issued. Then, my lord, and
We have taken steps, my lord.
Heard Mr. A.K. Gupta, learned counsel for the appellant. Also heard Mr. A. Bhattacharya, learned counsel for respondent number?
No, my lord, I am for the, in appeal, I am for the respondent number 1 and 2, my lord.
No,
And
heard Mr. A.K. Bhattacharya, learned counsel for the appellant. Also heard Mr. A.K. Gupta, learned counsel for respondent number 1 and 2. The notice issued to respondent number 3 has returned back with an endorsement within bracket insufficient address. Whereas service report in respect of respondent number 4 is awaited. What will you do, Mr. Bhattacharya?
I'll take instruction and then
First step.
press.
Learned counsel for the appellant submits that he may be granted some time to take instructions regarding appropriate address of the respondent number 3 and thereafter take fresh steps if required at the proper address. Prayer is allowed. The registry is also directed to place before this court the postal track consignment report of notice issued to respondent number 4 by speed post on the next date fixed. Let this matter be listed 12th of August.
okay, good. Item 26.
Yes,
This is also same, my lord, this I have filed for withdrawal of 50% of the amount deposited by insurance company.
Yeah, prayer that they give an undertaking because my lord, the amount of compensation has been awarded. So on the much on the higher side, yes. Of course, we are also my lord, claiming apart from other things, my lord, we are claiming that we have to pay and recover because the vehicle was not having my lord, the right endorsement. My lord. It was a hazardous my lord, carrying hazardous goods. So my lord, since my lord, 8 lakhs and odd my lord will be released. But they should give an undertaking, my lord, if the amount is reduced further, my lord, then my lord, they should refund the. Because my lord, about 16 lakhs have been awarded, my lord.
16 lakh 92.
My lord, taking into
how
account.
much reduction you are expecting?
My lord,
How much
my lord,
reduction?
106 months loss of income has been shown, my lord. I don't know what from what material this has been taken into account.
So
that,
will it be reduced to
that is not-
less than 8?
my lord, it may be
It
less
may.
than it can be less than because my lord, 106 months, my lord, loss of income has been shown, and my lord, 4 lakhs has been given on future treatment. My lord, nothing, my lord, nothing is born onto records. How these my lord amounts have been calculated. My lord.
Heard Mr. A.K. Gupta. IA. In IA. Heard Mr. A.K. Gupta, learned counsel for the applicant. Also heard Mr. M. Datta, learned senior counsel assisted by Mr. S. P. Roy, learned counsel for the
What respondent number 5?
respondent. You are appearing for respondent number?
I have the appellate one.
One, his for
Respondent number
Respondent
1,
one.
as well as Mr. S. Pegu, learned counsel for respondent number 3. This interlocutory application has been filed by the applicant slash claimant in connection with MAC appeal number 10/2025, praying for issuance of a direction for release of 50% of the awarded amount, which has been deposited by the appellant slash opposite party number 1 before the registry of this court in pursuant to order dated 10/1/2025, passed in IN civil number 73/2025 in connection with the MAC appeal number 10/2025. Learned counsel for the learned senior counsel for the insurance company submits that since in the connected appeal, the insurance company has questioned the quantum of the compensation awarded to the claimants. In the event this interlocutory application is allowed, an undertaking may be taken by the claimant slash opposite party that if required, they shall deposit back the amount before the court if so directed. I have considered the submissions made by learned counsel for both sides. Considering the averments made in this interlocutory application, as well as submissions made by learned counsel for both sides, the prayer for release of 50% of the awarded amount which was deposited by the insurance company into the claimants is allowed. The registry is directed to disburse the 50% of the awarded amount which was deposited by the appellant slash insurance company before it in pursuant to the orders of this court after proper verification, subject to submitting of an indemnity bond to the extent of amount which is to be released to the claimants opposite parties. This interlocutory application is accordingly disposed.
Diploma.
What is the status in the main appeal?
Verify. I just want to say this. Sorry, that was not verified. You were getting for respond number?
Service.
Five.
Heard Mr. M. Dattol, Senior Counsel, assisted by Ms. S. Namtuli, appearing for the appellant. Also heard Mr. A. K. Gupta, appearing for respondent number 1, as well as Mr. S. Pegu, appearing for respondent number 5. The service report in respect of the notices issued to respondent number 2 to 4 is awaited.
My friend appears for 4. In a New Indian. My friend appears for 4, so 2 and 3 is awaited.
2 to 3, 2 and 3 is awaited. Await further. Let this matter be listed. 21 July. The registry is directed to place the postal track consignment report of notices issued to respondent number 2 and 3 by speed post before this court on the next date fixed. List accordingly on 21st July.
Diploma.
Hold hearing under order 41, item 19.
May it please allow. One of the plaintiff's suit for recovery of possession was dismissed. Consequently, appeal was filed, my lord. Appeal was also dismissed. One of the facts in a nutshell is that, my lord, the plaintiff's case was that, my lord, with 1 bigger land, it was divided among 3 brothers. And after it was divided among 3 brothers, it was a verbal partition. Now, these 3 brothers were staying in their respective portion. And in one portion, in the plaintiff's portion, there were 3 shop rooms. And in one of the shop rooms, he had allowed his nephew, my lord, who also have a share in this one third of that land, to run a bus counter. So, as the nephew, who is the respondent defendant, was nephew, was not vacating the suit premises, so he filed a suit for recovery of possession.
You filed this.
Yes, appellant, who is the plaintiff. Plaintiff filed a suit. So plaintiff's case is, it is divided among three brothers. They are residing in their three shares.
You are one of the brother.
No, I am the plaintiff, my lord. Yes, one of the brother.
One of the.
One of the brother. Now the defendant, my lord, have raised a, by way of pleadings have raised a case that no, this 1 vega land was a paternal property which ought to have been divided among the 5 brothers. So as it has not been divided among the 5 brothers, so the plaintiff is not entitled to that 1/3 share of land. So that is the defendant's case now.
How many brothers are there?
There are 5 brothers, but this land.
Defendant is also your brother.
My lord,
Defendant is also your
the
brother.
defendant is the nephew, because it was settled among my lord A, B, C. So A is plaintiff, B was one of the brothers whose son is the defendant, my lord.
Okay.
And the other brother is there. He has also demarcated his land and he is staying there. Now the defendant's case is that, my lord, this land was inherited by the 5 brothers and it should have been divided among these 5 brothers, not amongst these 3 brothers. So that is the case which has been portrayed by the defendant. Now, defendant, my lord, did not adduce any evidence. Defendant adduced evidence of only one official witness, that is the Latmondi. Now the plaintiff, originally, my lord, the patta number was 1222. Out of this 1222, the plaintiff, who is the appellant before your lordship, he had carved out his share and a new part and a patta number 3684 was allotted. That means from Esmalit 1222, 3684 patta number was allotted in the name of the plaintiff. So accordingly, the plaintiff appellant was in possession of that land and the shop room was over that patta number 3684. As this defendant was not vacating the suit premises, so he filed a suit for recovery of wealth. Now, the court below proceeded during cross-examination. It transpired. My suit was of 2016, my lord. During cross-examination, a case was built up that this patta, which was allotted in the name of the appellant in the year 2000, was cancelled in the year 2019. That is after the filing of the suit. But that was not the pleaded case of the defendant that this patta has been cancelled. Now, on the basis of this cancellation of patta, the learned trial court proceeded to decide whether the plaintiff has right title interest of the suit land, suit premises, and whether the plaintiff is entitled to get back the recovery of suit premises. My lord, may I draw your lordships to the issues, my lord, page 15, page 50. Lord, before that, may I take your lordship to the plaint, my lord?
No, ultimately, on what basis your plaint was rejected?
A suit was rejected on the ground that this DAG number 3684, because it was my lord, cancelled in the year 2019. So as this 3684 is not available in the revenue records, so I don't have any right title interest over the suit property. Even assuming, my lord, for the sake of argument that yes, even if I don't have right title interest over that 3684, my Esmali right, which existed over that tag number 1222, my lord, that will revive. Now, the issue which the court has decided against me that I don't have any right title interest over the suit premises. Now, tomorrow, my lord, if I go for filing a partition suit, my lord, this will come as a hurdle to me. My lord, may I take your
What is the substantial question?
your questions of law? Page 4, my lord.
Which one is the substantial?
Yes, my lord. My lord, first of all, whether in a suit for eviction of a permissive occupier and recovery of khas possession, the learned courts below were justified in adjudicating issue number 5, whether the plaintiff has right title interest in respect of the suit premises and deciding the same against the
This is not a substantial.
Had there been a counterclaim, my lord, their case is that yes, it has been, this suit property had devolved upon 5 legal heirs. So if there ought to have been a counterclaim, my lord, that you are not entitled to this 1/3 share. Now, the court has decided then, number 2, my lord, whether the cancellation of appellant partition patta number so and so after 18 years, which came out of appellant's original Esmali patta number so and so, would take away the Azmali right title interest of the appellant which existence in the appellant's original patta number so and so. Now the court decides that as this 3684 is not in existence, so therefore the plaintiff does not have any right title interest over the suit claimant. Because even if we assume that this 3864 is not there, my lord, the Azmali right title interest of the plaintiff, which existed in DAG number 1222, my lord, that will revive. Then, my lord, number 3, whether the learned courts below are in law in failing to
Third, Mr. A. Das, learned counsel for the appellant. This appeal under section 100 of the Code of Civil Procedure 1908 has been filed by the appellants impugning the judgment and decree dated 2/3/2026 passed by the Court of Learned Civil Justice Senior Division, Sibsagar in title appeal number 13/2024, whereby the judgment and decree dated 21/10/2024 passed in title suit number 18/2016 by the trial court, that is the Court of Learned Civil Justice Junior Division number 2, Sibsagar, by which the suit of the present appellant was dismissed, was affirmed, and the appeal was dismissed. After hearing learned counsel for the appellant and after going through the materials available on record, following substantial question of law is formulated in this case. So whether the first appellate court as well as trial court committed perversity in arriving at the finding that the petitioner, that the appellant does not have any right, title, and interest in the suit land of which the original patta number was 1222. In view of the fact that the new patta number 3684 was cancelled in the year 2019.
Yes.
This is enough. Issue notice to the respondents. The appellant shall take steps. How many respondents are there?
Only one respondent.
Issue notice to the respondent. The appellant shall take steps for issuance of notice upon the respondent by speed post as well as by usual mode within 7 days from the date of this order, returnable on 7th of August.
May I play that one more ground that whether it is bad for other perversity, because the appellate court also will.
What perversity?
Lordship will kindly see the appellate court in what manner has dealt with at issue page 100. Lordship will kindly see appellate courts, how the appellate court has dealt with it. Page 100. Point.
No, tell me what perversity.
That is whether the provisions of order 41 rule 31 has been followed with my lord. My lord, this.
But that is not a substantial question of law.
That is my law, my lord. I have a judgment of Bombay High Court followed by Supreme Court judgment also, which says that, my lord, Lordship will continue whether the impugned judgment and decree are liable to be set aside. My lord, with all respect, my lord, the Bombay High Court judgment is not binding on this court, my lord, but for persuasive value, the Honorable Bombay High Court has said, my lord, that this type of judgment, that, my lord.
No, what is the substantial question of law?
Whether the, my lord, findings of the courts below suffers from perversity, my lord. Then, my lord,
that decision.
Then, my lord, I can argue this regarding order 41 also, my lord.
One on whether the impugned judgment of the appellate court as well as first appellate court
suffers from the vices of perversity.
vices of perversity,
Perversity.
least accordingly.
My lord, there is a stay application because they have filed execution for that it was dismissed with cost, my lord. They have filed an execution for cost, my lord.
No,
Pray that, my
he-
lord.
how there can be an execution?
They have already, my lord, I am annexed, my lord, and
How much
lordship
cost?
will- For recovery of cost. Lordship will kindly take the IA, my lord.
That you,
My lord, as your lordship has admitted it,
but in a dismissed
my lord,
suit, how there can be an execution case?
that for cost, my lord, my lord.
Where is that execution application?
Application, my lord, to IA 2019. In 2019, my lord, past page 63, my lord. In both the courts, they have filed an execution application, my lord. Page 63, lordship will see, my lord. To page 63, today is fixed for service report. Notice upon the JD has returned after due service. Parties are represented. Learned counsel for JD White petition number so and so filed wakalatnama. Praise for adjournment showing cost seen allowed fixed so and so for payment of cost. This is by the trial court and the appellate court also page 64, my lord.
How much is the cost?
Lord, 10,000 in one court, my lord, 10,127 in other court also, my lord, similar, 10,000 odd amount, my lord.
Heard Mr. A. Das, learned counsel for the applicant. This application under Order 41 Rule 5, read with section 151 of the Code of Civil Procedure, has been filed by the applicant in connection with the regular second appeal number 77/2026, praying for staying of the operation of staying of the execution in respect of the impugned judgment and decree dated 22/3/2026 passed by the Court of Learning Civil Judge Senior Division in title appeal number 13/2024 as well as judgment and decree dated 21/10/2024 passed in title suit number 18/2016 by the Court of London Civil Judge Junior Division number 2, Sibsagar. Learned counsel for the applicant submits that though the suit as well as appeal preferred by the present applicant were dismissed by the courts below, however, while doing so, a cost was imposed on the present applicant, and for realization of the cost, the defendants / present respondent have initiated an execution proceeding which has been registered as title execution case number 4/2026 pending before the Court of London Civil Judge. Two title execution cases.
Yes, one they have filed in trial court and one in the appellate court.
Title execution cases.
But case number is same.
Civil Judge Senior Division as well as Civil Judge Junior Division number 2, Sibsagar. Issue notice to the respondent. Since the connected regular second appeal has already been admitted, aforesaid likhibho This appeal is admitted, RS. Admitted and substantial question of law has been formulated. Further proceeding of title execution case number 4/2026 pending before both the executing court shall remain stayed till next returnable date. The petitioner shall take steps for issuance of notice on the respondents by speed post as well as by user mode. Returnable on 7th of August.
7th August. I'm deeply obliged.
Item 20.
That's it. May please also. I am a defendant. I'm the defendant in title suit number 114 of 14, page 17. Plaintiff has filed the suit for declaration that he is a occupancy tenant under defendant number 3. And further declaration that is solely executed by defendant number 3 in favor of defendant number 1 to be declared null and void because he is the occupancy tenant. He has filed the suit. And I have purchased the land from defendant number 3 in the year 2005. And I am occupying the land. And present.
You are defendant number?
I am defendant number 1.
Okay.
Page 17.
Okay. Thereafter?
Hereafter, in the suit, I have filed written statement denying him as a tenant. Defendant number 3 has denied that he is a tenant. And my sale deed was executed in 2005. And he has filed the suit for cancellation of that sale deed in 2014. And has also declaration that he is a occupancy tenant. Lordship will find the prayer at page 21. Lordship got it?
Yes.
Page 21. Suit is basically for declaration and recovery of position from me. Court of Seal বাদীৰ খতিয়ানদাৰ হিচাপে সকলো অধিকাৰ সুৰক্ষিত আছে বুলি ঘোষণা কৰক, declare কৰিছো। And court of Seal অবৈধ ঘোষণা কৰক। আৰু গোচৰীয়া court of Seal বিবাদীক উচ্ছেদ কৰি বাদীক খাস দখল দিয়ক। বাদী কৰা হেতে লিপিবদ্ধ কৰিবলৈ সংশ্লিষ্ট ৰেজিষ্টাৰ দিয়ক। আৰু 1 নং বিবাদী গোচৰীয়া জমিত অবৈধ দলিল হোৱা বুলি নামজাৰি খাৰিজ কৰক। আৰু গোচৰীয়া জমিত কোনো ধৰণৰ বাদীক হাৰাশাস্তি কৰাৰ পৰা বিৰত ৰাখি বিবাদীৰ বিৰুদ্ধে স্থায়ী নিষেধাজ্ঞা কৰক। So your Lordship knows that I have admittedly purchased the land in 2005. Lordship will find page 19. 3 sale deed I have purchased.
Yes.
117, 118 and 119 of 05. Para 9. I have purchased total 10 bighas of land by 3 reference sale deed in 2005. Admittedly, the suit has been filed in 2014. Declaratory suit, your Lordship knows, limitation is 3 years. A trial court also did not frame any issue regarding that this suit is barred by limitation. That is one thing.
You raised this plea in your WS.
Lordship. Secondly, Lordship, they have exhibited 2 khotian during trial. All these khotians do not have any sealed signature of the office. And that is admitted during cross-examination that these khotian do not bear any seal and signature of the officials. But trial court decreed the suit on the basis of the said khotian and declared the title. But trial court refused to declare that sale deed executed in my favor as so only relief is given that he was a tenant. Lordship will find the finding of the trial court at page, judgment start at page 28. And Lordship will find a decree. Page 38. Lordship got it?
Yes.
Order. In view of the discussion made in the plaintiff is partly decreed on contest hereby declared that the plaintiff is the khotiyender of the suit land and he is being occupancy tenant has right to possess the suit land. He is entitled for recovery of possession and same as he was not lawfully evicted. However, he is not entitled for a decree for declaration of sale deed number Iman and Iman being void and cancellation of the same. So it is basically a declaratory suit. It is barred by limitation. Secondly, Lordship will, I can show the evidence part. And during cross-examination, he has admitted that the khotiyan produced by him do not bear any sealed signature of the officer concerned. And as per section 54 of the Assam Land and Temporary Tenancy Act, to prove khotiyan, Lordship will find section 55 of the Assam Temporary Tenancy Act.
What is?
A notification in the official gazette of an order under section shall be conclusive evidence that the order has been duly made. So tenancy must be proved by producing the gazette notification and calling the revenue record. Here, Lordship will find the state of Assam was not made party. Secondly, his notification, Assam Temporary Settlement Tenancy Act 603, page 603. Section 55(2). A notification in the official gazette of an order under this section shall be conclusive evidence that the order has been duly proved. But here in this particular case, no notification and khotiyan also not proved by calling the revenue official, and there is no seal and signature of the revenue official in the khotiyan produced by before the authority. But trial court has decreed the suit, and suit is basically barred by limitation. And section 3 of the limitation act, Lordship is aware. May I read section 3 of the limitation act?
What substantial question of what the appellate court has done?
Appellate court also confirmed the decree, but no declaration regarding sale deed. No decree has been
You
filed.
raise this, please, before the appellate court.
Also, yes. Secondly, Lordship, one thing. Made it section 3, bar of limitation.
Yes.
Subject to the provision contained section 4 to 24, every suit instituted appeal preferred application made after prescribed period shall be dismissed, although limitation has not been set up as a defense. Here we have taken the defense also. Lordship can see the WS. We have annexed the WS. Page 23.
But no issue was framed.
No issue was framed. Suit is barred by limitation. But trial court did not give a decree declaring the sale deed executed by defendant number 3 in favor of me as.
So what substantial question of?
Lordship will find at page 10.
Section notification under section 55.
2.
2 is
Mandatory.
no. I am putting a query. Notification under section 55(2) is a conclusive proof of
Lordship.
tenancy.
Lordship, when khotiyan has been denied by the defendant number 3 during his WS, it is burden of the plaintiff to prove that khotiyan was duly executed. And the khotiyan which has been exhibited do not bear seal and signature of the revenue officials. That has been admitted by the plaintiff during cross-examination. When no proof, marking a document is not a proof. Lordship is established principle. Without proving the documents that it has been issued by the revenue officials. I have specifically denied there is a khotiyan in favor of plaintiff. When khotiyan is dispute, there is no khotiyan, then they cannot claim without proof that same. They at least call the revenue officials to prove the khotiyan which has been exhibited as document number 1 and 2.
Okay. Heard, Mr. S.K. Goswami. the learned counsel for the appellants. This appeal under section 100 of the Code of Civil Procedure read with Order 42, Rule 1 of the said code has been filed by the appellants impugning the judgment and decree dated 6/3/2026 and 12/3/2026 respectively, passed by the Court of Learned Civil Justice Senior Division Nalbari in the title appeal number 7/2020, whereby the judgment and decree dated 22/3/2020 and 11/3/2020 respectively, passed by the Court of London, Munsif number 1 Nalbari in title suit number 114/2014 was upheld, and the
Suit was partly decreed.
suit was partly decreed. After consideration of the learned counsel's submissions made by learned counsel for the appellant, as well as after going through the materials on record, following substantial questions of law are formulated in this regular second appeal. Number 1, whether the trial court as well as the first appellate court committed perversity in holding that the occupancy tenant in regarding the plaintiff to be an occupancy tenant without there being any notification to that effect under section 55 within bracket 2 of the Assam Temporarily Settled Areas Tenancy Act 1971. Number 2, whether the trial court as well as the first appellate court committed perversity in declaring the suit of the plaintiff, ignoring the fact that the suit was barred by limitation. This appeal is admitted for hearing. Issue notice to the respondents. The appellants shall take steps for issuance of notice upon the respondents by speed post as well as by usual mode. Within 7 days from the date of this order, returnable on 7th
So
of.
decree is already executed during COVID period, and he has recovered the recovery of position has been executed regarding recovery of position. Only thing is, Lordship, if occupancy tenant is declared by the court, he can take the right of ownership as per temporary security act by depositing the revenue, like 4 times of revenue. So we have filed a stay petition. If title is again acquired, then I have to file a separate suit again. Already decree has been executed regarding recovery of position.
No, what you want to stay?
I only pray for stay of the decree regarding acquiring of ownership. Only
But
basis
for
of-
that any steps has been taken.
Lordship, according to my information, he has taken steps. That is why I have filed a petition for stay of the municip order only. Because if he acquired the ownership, there will be another problem to file another suit for cancellation of the ownership.
No,
Decree is
we
already, Lordship may record that I have made a submission that decree is executed regarding
we
position.
will issue notice
Lordship.
in reflecting your submission without granting any stay now.
Status quo as on today, Lordship.
Yes. I heard Mr. S.K. Goswami, learned counsel for the applicant. This interlocutory application has been filed by the applicant in connection with regular second appeal number 80/2026, praying for stay of the decree of the trial court
Lordship, may I record my submission that
regarding declaring the respondent as occupancy tenant of the suit premises. Learned counsel for the applicant submits that the decree as regards recovery of the possession of the suit land has already been executed. However, he apprehends that since the respondent has been declared to be an occupancy tenant, he may pray for ownership right on the basis of such tenancy, and therefore he prays for status quo, granting of status quo as regards the occupancy right of the, as regards the decree to the extent of declaring the respondent to be an occupancy tenant. Issue notice to the respondents. The applicant shall take steps for issuance of notice upon the respondent by speed post as well as by usual mode within 3 days from the date of this order, returnable on 7th of August. As regards the status of the decree holder in respect of the suit premises, the status quo shall be maintained as on today till the next returnable date, least accordingly.
Obliged.
That will be right.
Yes.
This is an appeal by the defendant.
Defendant.
Plaintiff's suit was decreed by the trial court and affirmed by the first appellate court. Against that, I have preferred this appeal, my lord. The suit is for declaration of title in respect of the entire plot, which is described in Schedule A. And Schedule C is the 1 kata land in respect of which recovery of possession has been paid.
Yes.
The plaintiff's case is that about 3 bigha and 1 kata of land he and his wife together had.
Yes.
Plaintiff's father and mother. So out of that, my lord, his case is that page 11, lordship, may just kindly see, I'll just draw your lordship's attention to 2-3 lines. Plaint at page 11, my lord.
Yes.
Just 2 lines, the last 2 lines of paragraph 2 above paragraph 3, my lord. Thus both, lordship is got, my lord.
Yes.
Thus both Hafizuddin and Maimannesa became the owner of 3 bighas, 1 kata, 2 lecha, both in dag number 139 and 140. This is his case. His father and mother together had 3 bigha, 1 kata, 2 lecha.
Okay.
Now in paragraph 2, next paragraph, paragraph 3, he says that the plaintiff late Tamizuddin, the father of the principal defendant, that is present appellant's father, and Waziuddin, Samsuddin, Rafiquddin, and one Faizuddin are the sons of Hafizuddin and Maimannesa. So both these 2 had these sons, it may be mentioned that Hafizuddin, the father of plaintiff, gifted 1 katha of land from his share in Dag number 139. White give it is so and so. Lordship, will kindly see the year number of the year 1991 to his wife Maimunennesa, since deceased, and thereafter both Hafizuddin and Maimunennesa had gifted away total 3 bighas of land from their share in Dag number 139 and 140 to their 4 sons, namely plaintiff, Faizuddin, Wazuddin, and one Samsuddin, by separate deeds of gift covering 3 katha 15 lesas each from Dag number 139 and 40. The other 2 sons, Tamizuddin and Rafiquddin, were given separate share in other land. Hafizuddin and Maimunennesa, of Hafizuddin and Maimunennesa, the daughter of late Hafizuddin, was given marriage, and they did not claim any share property left by Hafizuddin and Maimunennesa. Now the property of 3 katha for 15 lesas in Dag number 139 and 40 that was gifted away by Hafizuddin and Maimunennesa, by gift deed number so and so 1991. Same date, what should kindly see, is the subject matter of the suit land, of the suit, my lord. This paragraph 3 says, my lord, out of the total 3 bigha 1 katha, let us forget about 2 lichas for the time being, my lord. 1 katha father had already given away by way of gift to the mother, that means donor's wife. He is left with 3 bighas, my lord.
Yes.
Now, out these 3 bighas, entire 3 bighas of land, the plaintiff is saying, was gifted to 4 sons and by separate gift deed. One such gift deed is the gift deed of 1991 to him. That means his father. Lordship, that's why I read this paragraph, covering 3 katha 15 lesas each. So separate gift deeds in respect of separate sons.
How much then by each deed?
3 katha 15 lesa each.
Okay.
Total is 3 bigha. Now that way he wants to say that entire land is exhausted. And then his further case is that, my lord, the next page, paragraph, page 12, paragraph 4, that on the western side,
yes,
paragraph 4, my lord, that the plaintiff who became the owner of the suit land had entered into the possession by mutating his name in the revenue record and by constructing residential houses over a portion of the suit land to the knowledge of the all without any disturbance from any quarter. Now this is important. It may be mentioned towards the western side of the suit, there remains a portion about more than 1 katha of land lying vacant. The plaintiff used the same as for seasonal plantation, etc. The principal defendant, that is the appellant before lordship, who have no right, title and interest over the suit land in and about month of November 2008, had forcefully entered into 1 katha of land from the southern, that is from the roadside, and disposes the plaintiff from the same. This is his case, my lord. Now, I'm just repeating, my lord. Plaintiff says his father and mother together had 3 bigha 1 lecha. 2 lecha, let me forget for the timing, my lord. Out of that, 1 katha was gifted to his wife, that is plaintiff's mother. Remaining 3 bigha to 4 sons by 4 separate gift deeds.
3 katha 15 lechas each.
Now, in the trial, my lord, plaintiff proves only his gift deed. The gift deed in respect of others, it is his pleading only. All of them were made pro forma defendants. Nobody came and contested the suit. So their gift deeds were not proved. Whether there was a gift at all or not, he could not prove it. So, from 3 bigha 1 katha, only 3 katha 15 lechas of land gifted to plaintiff's father has been proved.
Okay.
And remaining land, whether it was actually gifted by 3 other separate deeds or not, no proof is there. All of them were made pro forma defendants. All the sons are there. Nobody came forward to contest. Now, defendant's case is, my lord, that he was given one cut of land by way of a gift by father.
Whose father? Plaintiff's father.
Yes, they are brothers, my lord. Plaintiff's father gave away one cut of land to defendant number one's father. That your lordship will find page 19, my lord. Page 19, if your lordship kindly turns to
Yes.
the first subparagraph, my lord. To grab the land, lordship has got.
Yes.
To grab the land of answering defendant, the plaintiff have suppressed the truth. The real truth is that the answering defendant has been in possession of one cut of land covered by DAG number 140 and PP number 120 under Moja so-and-so, Nagaon, Assam, by right of inheritance from his father, Tamizuddin, since this is. Tamizuddin, the father of answering defendant, got the aforesaid land by way of a gift from his father, Hafizuddin, on 7/6/1993. Hafizuddin, after execution of the gift deed in respect of one cut of covered by so-and-so, on 7/6/1993, my lord, had delivered to Tamizuddin the possession of the gifted land. After taking possession of the gifted land, had been in continuous possession of the gifted land at the knowledge of all, and Sahabuddin in particular, without any disturbance from any quarter. After the death of Tamizuddin, his son, the answering defendant, has been possessing the said land by right of inheritance since the death of his father. Plaintiff has no sort of right, title, interest over the land on which answering defendant has been enjoying possession by a dwelling house which has been built with pakka wall with CI sheet roofed. Be it mentioned that plaintiff, without any right, title, interest over the land in possession of the answering defendant, out of greediness of the plaintiff, has filed this suit to harass the defendant without any reasonable cause. This is the defendant's case. Now, this, my lord, my gift deed was of 1993, his gift deed was of 1991. He could not show in the trial that after giving land measuring 3 kata 15 acres to him, the other land were actually given to other brothers by a separate gift deeds. It is only pleading. No evidence, no document. Now, so far as defendant is concerned, he has shown that this is a gift deed of 1993. And after the gift deed, his father got possession, constructed a house. There is a dwelling house. They are residing there. And after about 20 years, in 2012, this suit is filed saying that no, you have dispossessed me from a vacant land. What is the present position? That also he did not say. Now, trial court, my lord, finds both the gift deed are valid. Lordship is aware, under the Mohammedan law, gift deed is not required to be a registered document. If there is a delivery of possession, acceptance, and donation.
Oral gift.
Yes. Now, in the present case, my lord, trial court has come to a finding that both the gift deeds are valid. But since the gift deed in favor of defendant number one is a subsequent in a point of time, the trial court is saying, and possibly under the impression that other land is also gifted away to other sons. So father is left with no other land. So same land has been gifted twice. So his was prior in point of time. My one is subsequent. So I don't have any right. But my gift deed, when I make a specific pleading and I prove the document, plaintiff does not file any counterclaim challenging my gift deed. This is one aspect of the matter, my lord. Second is, my lord, the plaintiff has given in Schedule A the
all gifts were made by written gift deeds.
Both, yes, both are written. Plaintiff's one is also written, my one is also written.
And other three are not on record.
Other three are not at all proved by the plaintiff.
Okay.
Other three, my lord, Donnies, they were parties, they did not come forward to support his case. That means after giving a gift in his favor of 3 kata 15 lecha, father did not part with his other land. He has retained his land. He has made a false statement, because that is why other brothers could not come and prove their gift deeds.
Okay.
Now, trial court says that since my one is subsequent in point of time, father did not have any
Remaining land.
Yes. Now the question is, my lord, the another aspect, very important aspect is, plaintiff has given a schedule of boundary of entire land in Schedule A. I'll just point out, my lord. Lordship will kindly see. That your lordship will find at page 14, my lord, it starts.
Page
14.
yes.
Now, since there are two different ducts, 139 and 140, he has given a breakup in Schedule A. Land measuring 2 kata 16.75 lecha out of 2 biga 7 lechas in dag number 139 and 18.25 lecha of land out of 1 biga 4 kata lecha in dag number so and so. There is 140 my lord, PP number 120 of Rangagar Haj Hussein Kisam Kasamari, Nagaon, etc. Total, kindly say, total 3 kata 15 lecha. So his give date is for 3 kata 15 lecha. He has given in the schedule cop. Now, Lordship, kindly see the boundary description. Next page. I am concerned with northern side, my lord. Northern side is one Noor Muhammad. It was wrongly typed here. Now, Schedule B is in respect of 2 kata 15 lecha, of which, according to the plaintiff, he is in possession. He has been dispossessed by the present appellant from the Schedule C land, which is 1 kata. So 2 kata 15 lecha plus 1 kata, total 3 kata 15 lecha. This is his case, my lord. Now,
And you are claiming that this 1 kata has been
I have
gifted to your father.
Yes, and I have made a specific pleading in the written statement. This is my land. Now there is a requirement of identifying whether Schedule C land is a part of Schedule A land. Now I just pointed from the my lord, evidence, my lord. He admits in cross-examination that Schedule C land is different. And this is cross-examination of PW1.
Yes.
My lord, Lordship will kindly see after the first paragraph, last line of first paragraph, he says, I have underlined it with red ink, my lord. Gosorio Ekota Matir Sohod. Uttore More Nijamati. On the northern side, his own land. And in Schedule C, he says on the northern side is Noor Muhammad, which is staying with Schedule A.
Who is Noor Muhammad?
Noor Muhammad is on the northern side.
Who is he?
He is different from third person outsider.
Oh, okay.
Now, Schedule C, he says the 1 kata of land of which he has been dispossessed by defendant number 1 is 1 kata bounded with 3 descriptions, my lord. And in the cross, he examines that on the northern side, he is there. The reason is, my lord, he isn't possibly thinking that there is some vacant land, and this vacant land pleading he makes after 20 years. And I am saying that I have got a dwelling house, I am residing there. So unless this C schedule land is proved to be a part of Schedule A land, how can you get a decree of recovery of possession? So well, that is why I have framed a substantial question of law. Lordship will kindly see at page in my memo of appeal, my lord. Page 7. Father is left with enough land to gift to me. And he says that it has been given to some other brothers, so there is no land left. I have framed it in this way, manner, whether it's only on perversity basically, whether the learned courts below were justified in passing the decree for recovery of possession of Schedule C land, measuring 1 kata in possession of the appellant defendant number 1, without considering the pleadings and evidence on record that the father of the plaintiff and defendant had more than 3 kathas and 15 acres of land in Dag number 140 to donate 1 katha of land to appellant defendant subsequently. Because he has been able to prove only.
Or without considering that C schedule
Yes.
land is the part of A schedule.
Yes, either way.
Any execution case has been filed.
My lord, I have mentioned in my stay petition.
Heard Mr. D. Mujumdar. The learned senior counsel insisted by Mr. D. Mujumdar, the learned counsel for the appellants. This appeal, this regular second appeal under section 100 of the Code of Civil Procedure 1908 has been filed by the appellant Tahir Ali, impugning the judgment and decree dated 6/3/2026 passed by the Court of London, Senior Civil Judge Senior Division Nogao, in the title appeal number 3/2022, affirming the judgment and decree dated 9/9/2022 passed by the Court of London Civil Judge Junior Division number 1, Nogao, in title suit number 201/2012, whereby the suit of the plaintiff was decreed and same has been affirmed by the First Appellate Court. After considering the submissions made by learned senior counsel for the appellant, how many appellants are there?
Sole appellant.
Appellant, as well as after going through the materials available on record, following substantial question of law has been formulated in this appeal. Whether the trial court as well as the First Appellate Court committed perversity in decreeing the suit of the plaintiff for recovery of the possession of Schedule C land within bracket measuring 1 katha bracket close without considering the pleadings and evidence on record, suggesting that the Schedule C land is not the part of Schedule A land, and the father of the plaintiff and the defendant had sufficient land to donate 1 katha of land to the present appellant / defendant number 1 subsequently after donating 3 kathas 15 acres of land to the plaintiff.
In place of father, Lordship may write original owner Hafizuddin.
Alam body
Late Hafizuddin. Late Hafiz. In the last line.
Substantial question. Instead of father of the plaintiff, within bracket likhibo, late Hafizuddin.
Plaintiff is my uncle. My father and plaintiff were brothers. And their father Hafizuddin was the original owner.
Hafizuddin. Tarpisod. Your case is that even after donating 3/15 lectures land to the plaintiff, Hafizuddin had sufficient land to
Sufficient.
donate 1 kata to you,
Yes.
and this aspect was not taken
Not
into
taken.
account. Issue notice to this appeal is admitted for hearing. Issue notice to the respondent. The appellant shall take steps for issuance of notice to the respondent by speed post as well as by usual mode within 7 days from the date of this order, returnable on 10th of August. IA is there.
My eye is there. Execution case has been filed only, number is also there.
Heard Mr. D. Majumdar, learned senior counsel assisted by
Page
Mr.
11,
D.
I.
Majumdar, learned counsel for the applicant. This interlocutory application under Order 41, Rule 5 of the Code of Civil Procedure has been filed by the applicant in connection with regular second appeal number 81/2026, praying for stay of execution of the impugned decree which is sought to be executed in title execution case number 12/2026 during the pendency of the connected regular second appeal number 81/2026. Learned senior counsel for the appellant submits that the regular second appeal, the connected regular second appeal has already been admitted and substantial question of law has been formulated therein, and notices are also issued to the respondent. He submits that since the decree holder has already initiated execution proceeding by filing title execution case number 12/2026, unless the proceeding of said title execution case is stayed during the pendency of the connected regular second appeal, the present applicant would be highly prejudiced. Stop. Issue notice to the respondent. The applicant shall take steps for issuance of notice upon the respondent by speed post as well as by usual mode within 7 days from the date of this order, returnable on 10th of August. Stop. In the meanwhile, considering the submissions made by learned senior counsel for the applicant, as well as considering the fact that the connected regular second appeal has already been admitted, the further proceeding of title execution case number 12/2026 shall remain stayed till next returnable date. List accordingly.
After the case number pending in the court of Civil Judge Junior Division.
Title execution case number so and so pending in the court of
Number
Civil
two,
Judge.
number 2, Nagaon.
Civil Judge Junior Division, number 2, no. List accordingly.
All right.
RSA. Oh, main appeal, yes. Record may have to record.
Records may record.
RSA call for the records of the trial court as well as first appellate court. Registry to take steps for requisitioning the record.